Your Honor, we are now streaming live and you may proceed when ready.
All right. And did you receive my question in the chat before we get started?
Which question, Your Honor?
Whether or not I would be scoring as well or simply presiding.
You will not be scoring today. You will just be presiding over the courtroom.
Okay. All right, then. Let's go ahead and get started. Today, we are calling to order the case of People of Colorado versus Avery Becker, case number 20CR310 in the District Court of Denver County. And before we begin, I will go ahead and administer the oaths to the various teams and witnesses and gallery. Team members, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of this mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Gallery members, including teachers and attorney coaches. I don't know if there are any family members or friends here because this is somewhat unusual doing this online. Please raise your right hands. And do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? No response? All right. And scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts and procedures and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right. With all that being said, let us go ahead. Let me actually, give me just one moment. All right, then I believe with that, we will go ahead with opening statements for the prosecution.
Your Honor, before we begin, may the prosecution introduce themselves?
Yes, please, please.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Colby Lish, and today, along with my co-counsel, I represent the people of the state of Colorado in the matters of the state versus Avery Becker. I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Ms. Taylor Perkins, and that is all. May my co-counsel please introduce themselves.
Yes, please.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Zarina Yufa, and today I will be conducting the direct examination of Mr. Alex Cifuentes, the cross-examination of Mr. Avery Becker, as well as delivering the closing arguments.
Good morning, Your Honor. Good morning, ladies and gentlemen of the jury, and good morning, opposing counsel. My name is Jordan Davidson, and today I will be delivering the direct examination of Ms. Kyle Kuzak, the cross-examination of Mr. Van Owen, as well as delivering the opening statement for the prosecution. May our witnesses introduce themselves?
Yes, please.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Connell Barton, and I am Jordan Markowitz.
Your Honor, ladies and gentlemen of the jury, opposing counsel, my name is Louis Sharp, and I am Alex Cifuentes.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Chloe Brantz, and I am Kyle Kuzak.
All right. With these, do you usually have the defense go after and introduce themselves? All right, then. Defense.
Thank you, Your Honor. Good afternoon. My name is Kavya Chidambaram, and I will be performing the opening statement, the direct of Avery Becker, and the cross of Jordan Markowitz.
Good morning, Your Honor. My name is Grace Admire. I will be performing the direct of Ms. Taylor Perkins, as well as the cross of Ms. Kyle Kuzak for the defense.
Good morning, Your Honor. My name is Eliza Wilson-Roussel, and I will be doing the direct of Professor Blake Van Owen, the cross of Alex Cifuentes, and I will be delivering the closing statement.
May our witnesses introduce themselves?
Professor Blake Van Owen this morning.
Good morning, Your Honor. My name is Nikki Gorman, and I am Taylor Perkins today.
Good morning, Your Honor. My name is Jamie LeMay, and I am Avery Becker.
Anyone further? All right, then. At this point, I believe that we go ahead with prosecution opening statements.
Your Honor, if we may,
Yes.
the defense has a few pretrial matters to state beforehand.
Pre-trial matters. All right. I did see. Yes. What are the pre-trial matters?
Your Honor, the prosecution has just a few pretrial matters that we would like to address. We would request that all jury instructions, stipulations, and the charges be constructively published to the jury.
Okay. Granted.
That during cross-examination, direct examination, openings and closings, we may stray about our virtual wells.
Granted.
We would ask that for the sake of expediency and due to the technicalities of Zoom, while exhibits are being screen shared for the purposes of authentication, the time is stopped.
Granted.
And we would ask that all time remaining from closing statements be reserved for rebuttal.
Granted.
We would ask that all rights afforded to the prosecution also be afforded to the defense.
Granted.
Thank you very much, Your Honor. The prosecution has no more preliminary matters.
Defense?
Yes, Your Honor. The defense asks that both parties may stay seated during examinations.
When you're referring to parties, do you mean
in the prosecution?
In the prosecution defense? All right. Granted.
The defense asks that exhibits be shown on the screen prior to admission.
Granted.
The defense asks that we may take a short a short pause between questioning so timekeepers may have time to get caught up and type the time into the chat.
Granted.
The defense asks that time will be stopped for technical issues and all delays caused by tech issues will not be counted.
Yes, granted.
And the defense asks that all preliminary matters upheld for the prosecution. Excuse me, that was already said. No further preliminary matters for the defense. Thank you, Your Honor.
All right. And give me just one moment. Okay, Any further matters before we begin?
No, Your Honor.
All right, then now let's go ahead with the opening statements.
May I proceed, Your Honor?
Yes.
On March 6th, 2020, a masked intruder breaks into a house on Flower Street. Just minutes later, the same masked intruder flees, leaving carnage in their wake. A dead body lies on the floor of the patio, a gaping wound in its shoulder. Just next to it, a knife drips blood. This is the corpse of Mackenzie Brackman, and the prosecution will show you today, beyond a reasonable doubt, that that masked intruder was the defendant, Avery Becker. Becker has been charged with 3 crimes: felony murder, second-degree burglary, and criminal mischief. Simply, the prosecution will show you that Avery Becker broke into Mackenzie Brackman's house, intending at least to vandalize. And while Avery Becker was in the house or running away from it, Mackenzie Brackman died. We'll show you that Avery had motive, means, and opportunity. But we will also show you how resentment seethes to anger, and anger explodes to fury. Let's start at the beginning. Mackenzie Brackman was a celebrated criminal defense attorney, one kind enough to donate his time to coaching a high school mock trial team. A team that Avery belonged to, at least until their expulsion. You see, Mackenzie Brackman set reasonable rules. Avery thought those rules didn't apply to them. You'll see this resentment through prosecution witness Alex Cifuentes, someone who's familiar with Avery's arrogance. You'll see it through defense witness Taylor Perkins, the defendant's best friend. You'll see it through Avery themselves. Now this resentment seethed to anger when Brackman demoted Avery from A team to B team. Rather than repent, Becker manipulated Taylor Perkins into dropping mock trial. Throughout this case, you'll see how Avery asks and Taylor sacrifices. Puppetry at its finest. Now, once Avery was back on the team, that resentment, that anger still lingered. And it exploded to fury one day when Mackenzie Brackman just asked Avery to work a little bit harder. Avery grabs a permanent marker, storms outside, and vandalizes Brackman's car. Brackman kicks Avery off the team for good. Furious, Avery texts Alex Cifuentes a plan to trash Brackman's house, saying, "I'm going to wait until he's at work, then break in and trash it. That'll show him." That'll show him. Becker intended to teach Brackman a lesson. It turned out to be a deadly one. The following day, on March 6th, Becker breaks into Brackman's house and flees with Brackman dead. Now this would be enough for you to convict Becker. But the prosecution is going to give you more. Prosecution is going to give you lead detective Jordan Markowitz, who will tell you that Becker's phone was at the scene of the crime when the crime was committed. We're going to give you Kyle Kuzak, who will show you how Brackman was alerted to Becker's presence, grabbed a knife, and Avery, full of resentment, anger, panic, and fury, won the knife in a struggle and brought the knife down through ribs, fascia, aorta. Mackenzie Brackman died. So remember resentment, remember anger, remember fury. So when my co-counsel, Miss Yufa, stands before you and asks you to find the defendant, Avery Becker, guilty, you know the answer. Thank you, Your Honor.
All right. And with that,
Your Honor, can you hear me at this moment?
yes, I can. Defense, your opening statement.
Thank you. Good afternoon. May it please the court, Your Honor, opposing and co-counsel, ladies and gentlemen of the jury. Today, I, along with my co-counsel, Ms. Admire and Ms. Roussel, are representing Avery Becker, a teenager who's here today because of a wildly oversimplified investigation and case. As you listen to today's trial, I ask that you keep 3 words in mind: incompetent, implausible, incompetent, and insecure. These 3 words represent the countless shortcomings found within this prosecution. Jurors, Mackenzie Brackman's death was a tragedy, but charging the young man that sits before you today wrongfully accused of this serious crime will not mend that tragedy. Avery Becker is presumed innocent, unless, after considering all of the evidence, you are convinced beyond a reasonable doubt that Mr. Becker, on the charge of burglary in the 2nd degree, unlawfully entered the dwelling and damaged the personal property of Mackenzie Brackman. And the furtherance of this crime on the charge of murder in the 1st degree caused the death of Mackenzie Brackman, meaning the burden of proof is held solely by the prosecution. But if opposing counsel fails to prove any one of these elements beyond a reasonable doubt, you must find Avery Becker not guilty. Now, the prosecution will try to convince you of their oversimplified story through a tale lacking motive and bursting with assumptions. But as you listen to today's trial, you will realize that their theory is frankly implausible, built up by incompetent witnesses and evidence that has been tarnished by insecurity. One such witness is Alex Cifuentes, a so-called friend to Mr. Becker. You will see how the prosecution relies on screenshots of a conversation they will claim Cifuentes had with Becker. But jurors, we urge you to take into account the insecurity and jealousy at play that will call into question the credibility of this evidence. The prosecution will also bring you an employee of the Denver Police Department, Kyle Kazak. You will discover that despite the fact Kazak will claim to have spent a tremendous amount of time organizing this case, the prosecution's incompetent investigative team still managed to lose evidence and furthermore come to implausible conclusions. Finally, you will hear from Jordan Markowitz. You will see how Markowitz expresses concern about other suspects, ones with far greater motive, but proceeds instead with an implausible bias. You will see how Markowitz time after time has the opportunity to collect comprehensive evidence, but neglects to do so. Pay close attention to how he has created an illogical investigation based on faulty concepts. You will recognize the implausible theory concocted by the prosecution when you hear from 3 credible defense witnesses, one of which is Taylor Perkins, who was with Mr. Becker the entire day of the murder and will confirm that he was nowhere near Mackenzie Brackman's home during the time of the crime. And although you may question Ms. Perkins' alibi, you will see that failure to confirm it through the use of CDR data was yet another of the many lapses in judgment by opposing counsel's incompetent investigative team. The prosecution will also bring you Blake Van Owen. Professor Van Owen is an expert in law enforcement, general police investigative tactics, cell tower analysis, and more. The professor will shed light on the many incoherent assertions made by the prosecution. Listen closely as he shows that evidence is not always as definitive or applicable as it may seem. Avery Becker is a teenager who got kicked off of a high school club. The prosecution will try to convince you that is reason enough to commit cold-blooded murder. But jurors, we urge you to listen carefully throughout this trial to Mr. Becker's motive, or more specifically, his complete lack thereof. Remember that past mistakes do not dictate future actions. The prosecution's theory is implausible, dependent on work by the incompetent, allowing for evidence by the insecure. Opposing counsel will try to build a purely speculative case based on anger, resentment, and a mystical masked intruder, which simply will not hold up to scrutiny. Their theory is just that, a theory. At the end of this case, you will have the opportunity to honor Mr. Brackman's memory. We ask that you do so in finding Avery Becker not guilty of all charges in favor of the defense. Thank you.
All right. With that, prosecution, it is time for your case in chief. So your first witness.
The prosecution calls Detective Jordan Markowitz to the stand.
All right. Mr. Markowitz, can you please state your name and spell your last name?
My name is Jordan Markowitz, Markowitz.
All right. You have already been sworn in. So, prosecution, your witness.
Thank you, Your Honor. Detective, will you please introduce yourself for the court?
My name is Detective Jordan Markowitz. I have been a member of the Denver Police Department for the last 13 years, working as a homicide detective for the last 7.
Could you describe the work that you do for the Denver Police Department?
Yes, like I stated, it is mostly homicide. However, I hold a specialty in cell phone technology and forensic data recovery.
Do you have any certification in cell phone technology and forensic data recovery?
Yes, I actually received a certification in that exact field from the American Academy of Law Enforcement.
And do you use that skill in your day-to-day work?
Yes, absolutely. I have downloaded the cell contents of hundreds of cell phones and testified in 50 cases using it.
The prosecution now moves to tender Detective Jordan Markowitz as an expert homicide detective and an expert in forensic data recovery.
All right. Defense, your response. Defense? All right, then. If there's no interest in voir dire or anything like that, he will be so tendered.
Thank you, Your Honor. Detective Markowitz, how are you introduced to this case?
On March 6th of 2020, I received a call that was needed at 444 South Flower Street, and so I went. Now,
Just to lay some foundation, is 444 South Flower Street in the state of Colorado?
Yes, 444 apologies, words. 444 South Flower Street is indeed in Colorado.
Now, when you received this call, did you go to the scene?
Yes, I did. And upon arriving, I noticed that there was a body prone within the front door of the residence.
Did you identify the corpse?
Yes, that corpse belonged to Mackenzie Brackman.
Did you notice the means of killing?
Yes, there was a large stab wound on his shoulder, and further inside, there was a bloody knife.
Did you document that knife?
Yes, I did. We took photos.
And did you take photos of the body as well?
Absolutely.
Would you recognize those photos?
100%.
The prosecution requests that Exhibit 1 be shared for the jury.
Yes. Will you be sharing it, screen sharing it, anything like that?
Yes, Your Honor.
All right.
Detective Markowitz, is this a fair and accurate representation of the photo that your team took of the body?
Yes, it is.
The prosecution now moves to admit Exhibit 1 into evidence.
Defense, any response?
No objection, Your Honor.
All right. It shall so be moved into evidence.
The prosecution would like to request that Exhibit 5 be shared.
Go ahead.
Detective Markowitz, is this a fair and accurate representation of the knife that you saw on the scene?
Yes, it is.
The prosecution now moves to admit Exhibit 5 into evidence.
Defense, any response?
No objection, Your Honor.
All right. It will be so moved.
Detective Markowitz, after you investigated the corpse and the knife, did you look around the rest of the house?
Yes, after securing those two pieces of evidence, I conducted a further investigation, upon which I discovered that no expensive items or valuables or electronics had gone missing, ruling out burglary.
Was that out of the ordinary?
Yes, it is. Typically in a home invasion, you would see expensive items going missing, as typically those are related to burglaries. In addition to those, I also noticed some peculiar activities in the kitchen, most specifically a broken plate on the floor and an open knife drawer near the back door of the residence.
Did you take photographs of those two things?
Yes, I did.
Would you recognize a photo of the knife drawer?
100%.
Prosecution requests that Exhibit 7 be shared.
All right.
Detective Markowitz, is this a fair and accurate representation of the knife drawer that you saw in Mackenzie Brackman's kitchen?
Yes, it is.
The prosecution now moves to admit Exhibit 7 into evidence.
Defense, any response?
Objection, Your Honor, relevance.
Response.
Yes, prosecution.
It is the prosecution's theory of the case that Avery Becker, upon entering Brackman's house, was not armed. Showing that a knife drawer existed and was open in Mackenzie Brackman's house would go to show the fact that Mackenzie Brackman, upon hearing Avery's entrance, grabbed a knife and used it for self-defense.
All right, I will allow this to be moved into evidence.
Thank you, Your Honor.
Detective Markowitz, based on what you see in the knife drawer and the knife that you recovered with the blood on it, do you believe that knife could have fit into this set?
100%. Most specifically, none of these knives appear to come from one set in particular. And so it would be logical that the knife that we found on the scene of the crime came from this drawer.
Thank you very much. Detective Markowitz, were there any home security systems in Mackenzie Brackman's home?
Yes, there was. Actually, upon arriving on scene, I noticed that there was a ring doorbell system installed.
And could you briefly describe for the jury, what is a ring doorbell system?
A ring doorbell system is merely a high-tech doorbell with a motion-activated camera mounted on it, so that when anyone approaches the residence, the motion sensor is activated, and thus it captures a video and then sends it to the owner's phone.
And were you able to search through the owner's phone for these videos?
Yes, we downloaded the contents of Mackenzie Brackman's phone, including those the ring doorbell footage.
Did you save those videos?
Yes.
And would you recognize a copy of one of those videos?
I would.
The prosecution would like to request that Exhibit 12 be shared.
Go ahead.
Is this a fair and accurate representation of the video that you downloaded?
Yes, it is.
Prosecution would now move to admit Exhibit 12 into evidence.
Defense, any response?
Yes, Your Honor. Objection, lack of foundation, authenticity.
Prosecution, could you lay any more foundation for this video?
Your Honor, I would request that that the objection be explained a little more. I'm not so sure about the lack of foundation.
May I respond, Your Honor?
All right. Defense, would you like to elaborate on your objection?
Yes, Your Honor. There is no date on this video, and therefore I believe that the opposing counsel has not laid enough foundation to prove what day this video was taken or where this video has come from.
Response, Your Honor.
Yes, prosecution.
Your Honor, I've laid the foundation that this video came from the Ring doorbell in Mackenzie Brackman's home. I've also laid the foundation that Detective Jordan Markowitz downloaded the contents of these videos from Mackenzie Brackman's phone on the day of March 6th. Therefore, the copy of this exhibit is from March 6th, which was downloaded from Mackenzie Brackman's phone, and it was formed by the Ring video that existed on Mackenzie Brackman's home.
All right, I will reserve ruling on this objection.
Thank you, Your Honor.
Detective Markowitz, once you downloaded the contents of Mackenzie Brackman's phone, did you look through any contacts?
Yes, I did. I actually discovered a large amount of contacts, both linking to his his professional work and his work with mock trial. Now, initially, I did consider the fact that it could be a disgruntled ex-client. However, the large amount of context and responses relating to mock trial led me to pick up a lead there as well.
What was the first lead that you investigated in mock trial?
Well, primarily, it was Alex Cifuentes, but first I got the contacts of every member of the mock trial team, and it just so happened I contacted Alex Cifuentes first.
Did you interview Alex Cifuentes?
Yes, I did.
And what did he tell you?
And Alex Cifuentes
Objection.
gave me a basic...
Calls for hearsay.
There's an objection.
Your Honor, if you would offer me a little latitude, I will show that this testimony is offered for effect on the listener rather than hearsay, or rather than the truth of the matter asserted, and is therefore not hearsay.
All right, well, first I would like to hear the full objection from defense, and then I will allow you to question. And after I have fully heard this, I will decide whether or not it will be admitted.
Yes, Your Honor.
Thank you.
Defense, what was your objection?
My objection was that this question calls for hearsay.
All right. Prosecution, you may go ahead with your question, and I will determine whether or not the effect on the listener is valid for allowing this in.
Thank you, Your Honor. Detective Markowitz, what did Alex Cifuentes tell you?
Alex Cifuentes pretty much gave me a basic rundown of the team dynamic. She revealed that there had been some past altercations between Coach Brackman and another member of the mock trial team, Avery Becker. And in doing so, I started to look into Avery Becker as a possible suspect in this case.
Did Alex Cifuentes give you any physical evidence that led to your investigation of Avery Becker?
Hang on, counsel. So what is your assertion for the effect on the listener here?
Your Honor, it's the prosecution's assertion that because of the testimony that Detective Markowitz heard from Alex Cifuentes, he proceeded to investigate Avery Becker. It's the defense's theory of the case that Detective Markowitz had a rushed investigation. This evidence goes to show that Detective Markowitz did go through the proper steps in investigating Ms. Avery Becker.
All right, I will allow it for the purposes of showing that this is what caused the detective to investigate Becker.
Thank you, Your Honor.
Did Alex Cifuentes give you any physical evidence that led to your investigation of Mr. Avery Becker?
There was no physical evidence exchanged at the time of the interview. However, he revealed that he had text messages from Avery Becker, and I was sent screenshots of those text messages after the interview had concluded.
And what about those text messages led to your investigation?
Those text messages essentially detailed Avery Becker's plan to break in and vandalize Coach Brackman's house.
Detective Markowitz, after receiving that evidence, how did you proceed?
Well, initially I attempted to get in contact with Avery Becker. However, I was stopped by an attorney. From there, I downloaded the CDR data from Avery Becker's phone.
And could you just briefly describe what is CDR data?
Yes, so CDR data is pretty much the tracing that happens when any cell phone connects to a cell tower. And in doing so, it allows me to approximate the location of that cell phone. So by accumulating the CDR data from Avery Becker's cell phone, I was able to essentially track her general location throughout the day of the murder.
And were you able to visualize this data?
Absolutely.
Would you recognize a copy of Avery Becker's CDR data?
Yes, I would.
The prosecution would like to screen share Exhibit 16.
Yes.
Detective Markowitz, is this a fair and accurate copy of the CDR data that you received from Avery Becker's phone on the day of March 6th?
Yes, it is.
The prosecution now moves to admit Exhibit 16 into evidence.
Defense, any response?
Yes, Your Honor. Objection, lack of foundation, hearsay, and speculation.
Would you like to explain the hearsay objection?
Yes, Your Honor. This is an out-of-court document being produced for the truth of the matter and therefore is directly hearsay.
May I respond?
Prosecution, your response to that?
Your Honor, as I was tendering Detective Markowitz, he offered a statement that said he's downloaded hundreds and hundreds of CDR data. As this is another copy of CDR data, it falls under the exception of hearsay 8036 as a regularly recorded activity, and as he is the chief detective on this case, it is him who is proctoring this data, so it is admissible.
May I respond, Your Honor?
Yes.
Your Honor, this response is not applicable to this piece of for this document, as Detective Markowitz is not the custodian of the data.
May I respond, Your Honor?
I'm actually going to go ahead and limit responses on this. I believe that your prior argument was compelling, prosecution. And I will allow it as Detective Markowitz has been tendered as an expert in this field, and this data is relevant to his expertise. With that said, defense, what were your other objections? It was speculation and what else?
Lack of foundation, Your Honor.
Yes, could you please, prosecution, lay some more foundation?
Yes, Your Honor.
Thank you, Your Honor.
Detective Markowitz, did you download the CDRs directly from Avery Becker's phone?
Yes, I downloaded the CDRs directly from Avery Becker's phone, and in doing so, I'm able to plot that on a map. For the sake of helping people understand, when I plot these, I'm able to see the cell towers and whatever antenna that the cell phone may have connected to.
And Detective Markowitz, are these the CDRs from March 6th?
Yes, they are.
The prosecution now moves to admit Exhibit 16 into evidence.
All right, and I will ask defense to explain your final objection of speculation.
Yes, Your Honor. The route produced on the document is purely speculative.
Would you like to elaborate how that is?
Yes. The route that, if you look closely on this document, Mr. Markowitz has drawn in a route that he believes that Avery Becker took on the day of the murder. However, that is a purely speculative statement, and Jordan Markowitz cannot speak to the location of Avery Becker, only the location of the phone.
As Mr. Markowitz has been tendered as an expert in this field, I believe that he is qualified to opine on this. However, your objection is noted, and it will be read into the record that this is Mr. Markowitz's opinion.
Thank you, Your Honor.
Yes. Prosecution may proceed.
Thank you, Your Honor. Detective Markowitz, could you please explain the dotted black line that is drawn on the exhibit?
Yes, so the dotted black line is the route that we had just heard about. In this case, that dotted black line passes through those 3 red cones that you see. Now, those 3 red cones represent the antenna that Avery Becker's cell phone connected to at the time of on the date of the incident, on the date of the murder. And that dotted line that you're referring to is not 100% conclusive, as I am not able to pinpoint the exact location of their cell phone. However, I do have timestamp data, which allows me to conclude that Avery Becker's cell phone was moving from the area around her house to the area around Coach Brackman's house at the exact time of the murder.
Now, Detective Markowitz, based on your expert experience and all of the exhibits that you brought forward today for this case, do you believe that on March 6th, 2020, in the state of Colorado, Avery Becker entered Mackenzie Brackman's home and killed him?
Objection, Your Honor. Speculation.
I'm sorry, I didn't hear that objection.
Speculation.
I am going to grant that, because this question calls for speculation on the ultimate outcome based on limited information. Prosecution.
Thank you, Your Honor.
May I respond, Your Honor, briefly?
Briefly.
Pursuant to Rule 704, an opinion on the ultimate issue is not objectionable if it comes from an expert unless it embraces the mental state of the defendant.
May I respond, Your Honor?
Quickly.
That was not my initial objection, and opposing counsel has failed to remedy the speculation issue.
May I respond to speculation, Your Honor?
One last response.
Your Honor, as an expert in this field, it is Detective Jordan Markowitz's job to pinpoint the defendant and where they were at the time of the burglary. It is well within his expert opinion to opine to the burglar and the murderer of Mackenzie Brackman.
May I respond?
No, I'm going to limit responses on this.
Thank you.
You do raise a good point about the expert being able to opine on the ultimate issue. However, I do agree that we cannot extrapolate the facts about a murder based on the information presented from the data that you have given us with respect to this. So I will bar that final question.
Yes, Your Honor. Detective Markowitz, did you arrest Avery Becker?
Yes, I did.
And do you believe that you arrested the right person?
Yes, I do.
Thank you, Your
Based
Honor.
on the compilation of the evidence, I believe I got the right person.
Thank you, Your Honor. I have no further questions for this witness at this time.
All right. Defense, cross-examination?
Yes, Your Honor. Mr. Markowitz, I'd like to start by speaking about some of the evidence you collected for this investigation.
Defense, could you speak up a little bit?
Oh, yes, Your Honor. Can you hear me now?
Yes.
Thank you. Let me reiterate. I'd like to start by speaking about some of the evidence you collected during your investigation. You say that you have downloaded the contents of hundreds of phones, right?
I have, yes.
But you didn't download the contents of Alex Fuentes' phone, did you?
No, I did not see the need to, as I'm an expert in the field.
Instead, you accepted screenshots.
Again, I did not see the need to. Screenshots are perfectly sufficient for what we needed.
The screenshots that were sent to you by a teenager.
Yes, I have no reason to distrust Alex Fuentes, and like I said, as an expert in this field, those screenshots are perfectly acceptable.
Thank you. And you used these screenshots sent to you by a teenager as evidence in a murder trial. Is that correct?
Yes, I did.
Thank you. Now, are you aware, Mr. Markowitz, you are aware, Mr. Markowitz, that screenshots can be altered, correct?
That is a possibility, I assume.
Meaning that there is no way to know for sure if these are unaltered screenshots, right?
I suppose so.
I would now like to speak about Ring doorbell camera data. Earlier during your direct, you said that you had downloaded the information from Mr. Brackman's Ring video account.
Yes, I did.
And you say that Mr. Brackman was alerted to an intruder through push notifications on his phone.
That is correct.
But you didn't download the information from Mr. Brackman's account that would tell us whether or not he even had notifications on, did you?
No, I did not.
But you still concluded that Mr. Brackman was alerted to the intruder by notifications from the video account, right?
That is correct.
And because of this, you say that Brackman confronted the intruder with a knife.
Yes, that is our theory of the case.
And your theory is that Avery Becker somehow got the knife and killed him with it.
Yes, Brackman was an old man. I do not see how it is illogical in any way.
Meaning to you that a teenager has wrestled a knife out of the grips of a grown man. Is that correct?
An aging man, and yes, teenagers can be quite strong.
Prosecution, was that an objection?
Yes, Your Honor. Asked and answered, as well as needlessly cumulative.
I'm still going to allow it.
Thank you, Your Honor. Now, let's move on to CDR data. You say that Avery Becker was at Mackenzie Brackman's home based on CDR data, right?
Yes, and that was tracking Avery Becker's phone and the general location of it.
Right, because Becker's phone had connected to a cell tower near Brackman's home.
That is correct.
So the data tells us that Mackenzie Brackman's home was somewhere within a 120-degree section of land extending out from a specific tower, right?
That is correct, and I never stated that it was a pinpoint measure. However, my entire conclusion was based on accumulation of evidence, not just the CDRs.
In fact, isn't it true that Mr. Becker's phone could have been even further than that and just happened to connect with that specific tower?
While it is a vague possibility, yes. However, most commonly it connects to the nearest tower.
That's a yes for the jury?
Yes.
Thank you. So the CDR data shows us a likely location of Mr. Becker's phone as it received calls and texts within the given time frame, correct?
Yes, it received calls and texts throughout the day.
But isn't it true that Mr. Becker may not have even had his phone on the day of the murder?
I hear that is a something that was proposed, and again, I'm not basing my entire conclusion just off the CDRs.
Meaning the CDR data does not tell us the definitive location of Mr. Becker at the time of Mr. Brackman's death, correct?
Not the definitive, but it gives us a general idea as to where they might be.
So finally, I'd like to speak about some of the suspects you investigated during your investigation. You said that the evidence at the scene of the crime made it look like Mackenzie Brackman had interrupted a random burglary.
I did say that, yes, and that was one of my initial thoughts before I concluded that no valuables had been taken.
You also said that the murder could have been the work of a disgruntled ex-client.
I considered the possibility, yes.
However, you did not note in your report that you pursued any such suspect, right?
I followed the facts of the case, and mock trial seemed way more likely due to the fact that he spent more time with mock trial than he did on his actual job.
But isn't it true that you also said it was highly unlikely that Brackman's death had been related to his mock trial activities?
I said that early in my investigation. As I continued my investigation, it became more likely.
Thank you, Ms. Markowitz. You had the contact information for all of the students at the school, right?
Yes, I did.
And you say that the first student you called gave you the biggest break in the case.
And yes, and let me reiterate, I had all the contact information for the mock trial students, and it so happened that that is correct.
Thank you. Now, would you agree, Mr. Markowitz, that it is important in a criminal investigation to pursue all possible leads?
Yes, which is why I investigated Avery Becker.
But nowhere in your report do you know interviewing any of the other students on the mock trial team. Isn't that right?
Yes, I did not see a need to.
You proceeded instead with your case against Avery Becker.
That is correct.
Thank you, Your Honor. No further questions for this witness.
All right, prosecution, would you like to redirect?
Yes, Your Honor, briefly. Detective Markowitz, why was Avery Becker your primary lead?
Avery Becker was my primary lead based on the accumulation of evidence and the text messages detailing his intent to break into Mackenzie Brackman's home, as well as the CDRs and the compilation of photos we found at the phone, as well as the ring videos. No one piece of evidence is the home run evidence, so to speak. They are all amazing piece of evidence, but to simply say I based all of my conclusion off merely the CDRs is incorrect. I based it off of everything, and that is my job.
Thank you, Detective Markowitz. Thank you, Your Honor. I have no further questions.
All right, then. Detective Markowitz, you may return to your seat. And prosecution, would you like to call your next witness?
Thank you, Your Honor.
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand. However, first, in the chat, I do see that there is a major discrepancy in time between the timer for the EE team and the timer for the HH team. Can we please have a moment to clarify that?
Yes. Yes. How long do you usually grant for these?
Your Honor, typically time discrepancies will be up to you to determine, and normally we default to the most remaining time, but it's up to you to determine.
Okay, so this is a discrepancy of, let me see. 1222 and 1456. Oh, wow, that is quite the discrepancy. Yeah, we'll go ahead and
Excuse me. I'm sorry to interrupt, Your Honor, but
yes,
other time for his misunderstanding. For the direct for the prosecution is 1222, and for the cross for the direct is 1456 for the defense.
All right. 12:22 for the prosecution. Okay. All right. I am not super familiar with timekeeping because that is not something I frequently do. I'm going to go ahead and default to whoever has the most time left on the clock, and we will go ahead and use that.
Excuse me, Your Honor, can I ask for clarification of what time that is?
Timekeepers. Who has the most time on the clock?
There's 14 minutes and 59 seconds left for the prosecution direct.
All right. Then we will go ahead and use that.
Okay, thank you, Your Honor. Your Honor, may I ask for a moment to reset my timers?
Yes.
Thank you.
Your Honor, permission to proceed. I'm not sure if the other timer has sorted out her timing discrepancies or not.
Timer, have you done so?
Not yet.
Not yet.
I will give you 20 more seconds.
Thank you, Your Honor. Okay, I am ready.
You ready? All right. Okay, then. Prosecution, your next witness.
Yes, Your Honor. Good morning. Can you please introduce yourself for the jury?
Hello, my name is Alex Cifuentes, and before you ask, yes, I can spell my name for the jury. It's Sifuentes.
Thank you, Mr. Cifuentes. How would you describe yourself?
Well, I would describe myself as a loner, passionate about mock trial, and a member of the Colorado High School mock trial team.
Would you ever use the word insecure to describe yourself?
No, I don't think people see me that way, and I won't describe myself that way.
Now, you mentioned that you were a member of the CHS mock trial team. Did you happen to be on the team with Mr. Brackman?
Yes, I did. Mr. Brackman was actually a coach of mine for about 3 years. Yeah, we were tight. He was a good guy.
What do you mean by you were tight?
Well, Coach Brackman was something of a mentor to me. I looked up to him, and everybody on a mock trial team has to be really tight. You have to be a cohesive unit. That's the pleasurable part of mock trial.
Who else were you close with on the team?
Well, I was close with the rest of the team members. I would say I was really close with Avery Becker.
Would you say that you were ever jealous of Avery Becker?
No, I wouldn't say I was jealous. Avery was an extremely successful member of the mock trial team, and it just seemed to me that, frankly, he didn't work as hard as the rest of the members of the mock trial team, and that really rubbed people the wrong way. It's understandable.
So you mentioned that people on the mock trial team were very close. Were you able to see anything concerning Avery Becker's relationship with Mr. Brackman?
Sure. Yeah, at first it was just little things. Avery would show up for practice completely unprepared. That was really difficult for Brackman to take, especially considering I would show up with a perfect direct examination. It was just those little things.
So what did Mr. Brackman do about that from what you could see?
Well, at first he just tried to discipline Avery, but that wasn't enough. Right before the regional competition, which is a big deal if you follow mock trial, Avery was actually demoted down to B team.
Was Avery ever able to make it back onto A team?
You could say that. I prefer to say he coerced Brackman into moving him back up to A team, but I guess to each their own. You know, it was a big deal on the team too. You know, normally people on mock trial follow sort of a steady rise. If you're like me, it's meteoric, but Becker rather, slid back downhill.
So did Mr. Becker's relationship with Mr. Brackman get better after that?
No. Things only went downhill from there. Actually, it all came to a head after the regional competition. That's when things got terrible.
And what do you mean by that?
Well, Avery actually performed very well during the regional competition. I'll give him that. He won some awards, but he showed up completely unprepared. That's sort of a theme here. And Brackman told them that in real life, that would be considered malpractice. That bothered Avery.
So what did Avery do?
Well, I remember, you know, after every case, we go do this big breakdown. And at the end of our mock trial room, we had this huge whiteboard. At the bottom of the whiteboard, there's all these markers. Well, Avery went over to the bottom of the whiteboard and took out one of the markers and ran outside.
What did Avery do once he got outside?
Well, he went over to Brackman's beautiful Porsche. That's how you know you got a good lawyer, when they drive a nice car like that. Wrote in big, bold red letters, worst attorney award.
Objection, Your Honor. This answer calls for hearsay.
And what is the hearsay?
This writing is an out-of-court statement offered for the truth of the matter and is therefore hearsay.
Response, Your Honor?
Prosecution, your response.
This writing is not being offered to prove that Mr. Brackman won a worst attorney award. This is being offered rather to show that Avery did the writing in the first place. The contents of the writing are not important, therefore it is not being used for the proof of the matter asserted.
I do agree with that, so I will allow it.
Thank you, Your Honor.
So what did Mr. Becker write on Mr. Brackman's vehicle?
Well, like I said, big, bold red letters, worst attorney award.
What happened to Avery Becker after that?
Well, Avery was off the team for good. That much was obvious, and you can't really blame Brackman for that. You just don't come back from that kind of thing.
Did you ever hear from Avery again?
Oh, yeah. Avery actually texted me asking me to apologize on his behalf. You know, apologies are one of my strong suits. I'm really good at them, and I can do anything.
Do you have the phone that Mr. Becker texted you on today?
Oh, not anymore, no. My phone didn't hold a particularly good charge. So why have a phone that you can't take anywhere? It's kind of the point.
Let the record reflect that I am asking our timekeeper to screen share a copy of what has been previously marked as Exhibit 14.
All right.
Mr. Cifuentes, rather, do you recognize these text messages?
Yes, I sure do. These are the text messages I received from Avery Becker.
And are you aware that this is a screenshot of those text messages?
Yes, ma'am, I am.
Are you the one who took this screenshot?
You know, Ms. Yufa, I'm a lawyer in mock trial. You don't have to go through all of this admitting an exhibit and make sure it's authentic with me. You know, I know it's authentic. I took the screenshots, fair and accurate, all that jazz, yeah.
Mr. Cifuentes, I don't know about the mock trial rules. However, these rules state that I do have to go through that. Now, are you the one who took these screenshots?
Yes, ma'am.
And are they a fair and accurate copy of the screenshots you took?
Yes, they are.
The prosecution moves to admit Exhibit 14 into evidence.
Defense, your response.
Yes, Your Honor. I object on the grounds of hearsay and lack of foundation.
All right. Would you like to elaborate on your objections?
Yes, Your Honor. For the hearsay objection, this is also Mr. Cifuentes' statement and is still hearsay. As for the lack of foundation, counsel has not established that these messages come from Mr. Becker's phone number, nor have they reliably established that this comes from Mr. Becker himself. Furthermore, there is no date on the PDF, nor is there a date on the screenshots themselves, and we cannot establish reliably where they were from or when they were sent.
I find your argument compelling, so I'm going to sustain the objection.
Can I actually respond to that objection?
Actually, I do think it is a fair and accurate objection, so I am actually going to go ahead and sustain that.
And which objection are you responding to?
I am responding to both the hearsay as well as the lack of foundation, unless you can provide some sort of metadata with respect to the accuracy of this screenshot. I don't know that I can fairly admit
Your
it.
Honor, pursuant to Rule 104, the judge decides the admissibility of a statement and the jury decides its authenticity. Pursuant to Rule 902, I have correctly authenticated the screenshot by asking Alex Cifuentes whether it is what he says it is, which is a screenshot of text messages he received from Avery Becker. It is a cross-examination matter for the defense to prove whether or not these were actually from Avery Becker. As for the hearsay objection, the statements made by Alex Cifuentes are not being offered for the truth of the matter asserted, and the statements made by Avery Becker are not hearsay pursuant to Rule 801 D2A.
Your Honor, may I respond?
I am still going to sustain the objection, and we are not going to further argue on this. I would like you to proceed with your case.
Thank you,
Yes, Your Honor. Can I ask the timer to please take these text messages down? Now, Mr. Cifuentes, what did Avery Becker do after he was kicked off of the team?
Well, Avery was really upset. I remember at some point him mentioning something about going over to Brackman's house.
Objection, Your Honor, hearsay.
Your Honor, this is not being, Your Honor, this is admissible pursuant to Rule 8033 because it is being offered to prove Avery Becker's plan to go to Mr. Brackman's house.
Your Honor, may I respond?
Yes.
The text messages in which this information is in have not been admitted into evidence. Therefore, I do not think that counsel can ask questions relating to them.
Response, Your Honor?
Briefly.
Your Honor, I'm eliciting a specific statement, not the entirety of the text messages as a whole. I'm asking Mr. Cifuentes about a statement that Avery made concerning Avery's plans to go to Mr. Brackman's house.
I am I'm going to allow the question. So you may proceed, prosecution.
Thank you, Your Honor.
So what did Mr. Becker say to you?
Something like, if you think Mr. Brackman was upset when he saw what I did to his car, wait till you see what I do to his house. That's when I knew things were getting disturbing.
And are you sure that this was Mr. Becker who said this to you?
There's no doubt in my mind. Yes.
And when did you hear this from Mr. Becker?
Well, that was hours before Brackman was killed.
Thank you, Your Honor. No further questions.
All right. Defense, your cross-examination.
Yes, Your Honor. Good morning, Mr. Cifuentes.
Good morning.
I'd like to talk to you about your relationship with Avery Becker. You knew Avery Becker through mock trial, correct?
Yeah. Yes, that's correct.
And you say you only really ever spent time together at mock trial?
Yeah, like I said, I'm a loner. Some people think I have a weird personality.
Thank you. And that really only means practices and tournaments with the occasional fry shack, correct?
Oh, yes, and Avery was my best friend.
Now let's talk about mock trial. You didn't like the way Mr. Becker treated the team or the coach, correct?
You're right. His showing up late and unprepared was disrespectful. I put a lot of time into mock, and so did everybody else.
Thank you. And according to you, he played the victim and never worked hard, yes?
That's correct.
And you don't think Avery deserved any of the awards he got, right?
I would say there are other people who deserve them more. But Avery, I have to give it to him. He was a good lawyer.
However, in your statement, you said you don't think Avery really had any talent.
That's correct. I think he was good at making things up on the spot. The jurors really liked him.
And you stated that you thought Mr. Becker, the team was better off without Mr. Becker, correct?
Yeah, certainly the morale and everything, yes.
And you were glad to have a bigger role now that Avery Becker was gone, correct?
At first that wasn't at all in my thoughts, but it turned out that I really did enjoy it. I'm a good lawyer, and the team needed me, so yes.
So for the jury, that's a yes.
It's a yes with a caveat, yeah.
And you said it irked you when Avery Becker would come in and just make things up as he went, yes?
Yes, absolutely.
So when Coach Brackman demoted Avery Becker from the A team to the B team, you thought it was rightfully so.
There's no other way to look at it, yeah.
But then Taylor Perkins quit the A team.
Yes, but there are some sort of suspicious circumstances around that. Would you like me to elaborate?
No, thank you. And Avery Becker was once again promoted to the A team?
I wouldn't say that, no.
And the whole team was really upset about Avery Becker being let back on the A team, right?
Again, I wouldn't say he was let back on the A team. He coerced the coach into moving him back up. Yes, we were all upset.
And the whole team, including you, were even more upset after Avery won awards at the regionals.
Yeah, I mean, he performed well, but he was unprepared.
And you said you think when someone who did not work hard gets awards, it's like a slap in the face to someone like you.
Yes.
Now, when Avery Becker was kicked off the team, there was a good chance that your team was going to have to forfeit going to state, correct?
Yes, and yes.
And you and the whole team were devastated.
Yes.
And that's all because of what Avery Becker did.
Correct.
You saw Avery Becker at Fry Shack the night before Coach Brackman was killed, correct?
Yes, that's correct.
And Avery let you play on his phone?
Yeah, briefly, that's what teenagers do, screenagers.
So it was in your hands and you were using it, correct?
Yes.
And this was the same phone you said sent texts to your phone?
I have no idea. I'm not sure.
Thank you. No further questions for this witness, Your Honor.
Prosecution, would you like to redirect?
No redirect, Your Honor.
All right. Mr. Cifuentes, you may return to your seat. Prosecution, do you have any further witnesses to call?
Prosecution calls Ms. Kyle Kuzak to the stand.
And actually, do we need a moment for our timekeepers to make sure that their times are correct and synced up?
That would be wonderful, Your Honor. While they do that, I'd like to ask as to the admitted status of Exhibit 12.
Exhibit 12, that was the video, correct?
Yes, Your Honor.
I am going to go ahead and allow that one in.
Yes, Your Honor. Your Honor, it appears that the timers have settled their dispute.
All right, then you may proceed. You called forward Kyle Cusack, correct?
Yes, Your Honor.
All right. Mr. Cusack, could you please say your name and spell your last name?
Oh, yes. My name is Kyle Kuzak. Okay, my name's Chloe Brants, B as in boy, Rants.
Okay.
Or Kyle Kuzak, Kuzak. That one. Yeah, I'm
all
Kyle
right.
Kuzak.
All right, thank you. Prosecution, you may proceed.
Ms. Kuzak, what's so interesting about a dead body?
Well, I mean, the fact that it's dead. Okay, I know that sounds super morbid, but, it's just that in my line of work.
Relevance.
Your Honor,
Yes. Your response, prosecution.
pursuant to Rule 401, relevant evidence makes a fact more or less probable. Now, Ms. Kyle Kuzak will testify that she is a certified crime scene reconstructor who works with dead bodies all the time. This is essential to establishing her credibility and her background for her job.
I would like you to go ahead and lay some foundation for her background before she gets into the more technical aspects of it.
May I tender an offer of proof, Your Honor?
Yes.
Just as Ms. Kuzak was cut off by opposing counsel, she was saying, it's important in my line of work. My next question is, what is your line of work? And her next response, we'll talk about what she does for a living.
Let's just jump into what her line of work is. If you want to re-ask the question after we have laid that foundation, you are welcome to.
Yes, Your Honor. Ms. Kuzak, what is your line of work?
I'm a certified crime scene reconstruction investigator, CSR for short.
What do you do as a CSR?
Well, I typically will show up to the crime scene. I'll document it, take the evidence back to my lab, try to not get blood all over my work clothes. I'll reconstruct the scene and then determine what happened. Sans actual body, of course.
So you've mentioned body a couple of times. Do you typically investigate violent crimes?
Well, that's complicated.
What do you mean by it's complicated?
Well, I specialize in complex crime scenes, so scenes that have the greatest wealth of advanced forensic subjects, including but not limited to home security systems, biological evidence, unclear event pathways. I mean, do those crimes have to be violent? No. But do they tend to be? Yes. So what that's going to mean is domestic violence, armed robberies, homicides.
Ms. Kuzak, how long have you been working as a CSR?
Oh, 19 wonderful, wonderful years.
Thank you, Ms. Kuzak. Your Honor, at this time, the prosecution moves to tender Ms. Kyle Kuzak as an expert in crime scene reconstruction with special emphasis in her specialties, home security systems, and biological evidence.
Defense, do you have a response?
No response, Your Honor.
All right, and what were the categories that you were tendering her in again?
Crime scene reconstruction with an emphasis in home security systems, as well as biological evidence.
All right, then, since there is no objection from the defense, she is so tendered.
Ms. Kuzak, what's so interesting about Mackenzie Brackman's body?
I would have to say that is the wound itself and the knife right by it.
Why?
Well, you've got the body on the stairwell floor and the knife just right there, a couple feet away, covered in blood.
So how did you use this evidence in your reconstruction?
Well, I frame all of this evidence in terms of a staircase.
A staircase?
Yes, a staircase. I mean, there are technical terms for it, bevel Gardner, 7-step, etc. But, the easiest way to visualize this is to think about the bottom left corner of your screen and imagine connecting it with boxes to the top right corner of your screen. Each of these boxes represents evidence leading from the unsolved crime in the bottom left to the culprit in the top right, like a staircase.
So the body and the knife, those are steps 1 and 2?
Yes, the body starts the investigation. So first we think, how did the body become dead? In this case, it's simple, the knife. Body step 1, knife step 2.
What's step 3?
Now you have to wonder how the body and the knife came in contact. Did the victim wound themselves? Not in this case. The wound goes through ribs, fascia, aorta. I mean, that would have had to be an incredibly strong blow, just unobtainable at this awkward angle. So somebody else stabbed Mackenzie Brackman. That's the third step, but it still doesn't answer where the knife came from.
What does answer that question?
Exhibits 7 and 8.
And to clarify, Ms. Kuzak, Exhibits 7 and 8, those are pictures of the knives in the drawer and the knife block?
Yes.
And what do those mean in terms of where the knife came from?
Well, there's an open knife drawer at the crime scene, right? And the knife block with the missing knife. So conceivably, the knife could have come from either of those places. There are enough loose knives that the brand of the knife doesn't matter. And either way, it suggests that the weapon came from the house. Of course, the next step would be to use security camera footage to be sure.
You have security camera footage?
Yes.
Timer, if you could please project Exhibit 12. Is this the video you mean, Ms. Kuzak?
Yes, it is.
Timer, if you could please stop the share. What does this video tell you?
Well, I want you to take a close look at the intruder's clothing. There would not be a room for a knife of this size to be hidden in those clothes. Step 4.
What's step 5?
Who picked up the knife?
And how do you know that?
The ring videos, the broken plate, the door opening, you can deduce from there.
What was your deduction?
Ring videos alert a homeowner of an intruder via phone message. If Brackman had those messages on, he would have seen them. If he didn't, there's the sound of the door opening and the plate shattering. That's step 5, almost at the top of the stairs.
Your Honor, pause. There seems to be an extreme discrepancy in the timing. I would like to ask, I think I know what the issue is, if opposing counsel has been stopping time when exhibits are being projected and no one is speaking like we established in preliminary matters.
Yes, timekeeper, have you been making sure to reserve the time that is being used for display of exhibits?
Yes, Your Honor, I have been.
Your Honor, there still seems to be quite a lot of discrepancy.
Yeah, we're going to go with the longer time.
Yes, Your Honor. Ms. Kuzak, if you don't mind if I re-ask the question.
Yes, go ahead.
My apologies, Your Honor. Ms. Kuzak, what was your deduction?
Well, since the intruder didn't bring a knife, Brackman was likely alerted, and Brackman knows the house better. He knows where to get the knife. So Brackman had the knife first rather than the intruder.
What does it mean that Brackman had the knife first?
It means there was some sort of scuffle backed up by steps 6 and 7, scuff marks by the door and the broken plate. And if the plate didn't break before Brackman was aware of the intruder, then it must have broken in an altercation. During that altercation, the intruder won the knife from Brackman and stabbed him.
Now, what gets us to the top of the staircase?
Well,
Somebody who does not bring a murder weapon to the scene of the murder, and someone who's jumped by an armed homeowner does not seem to me like a planned murderer. That's step 7.
What's step 8?
Well, you read the text messages that Avery Becker sent, planning to trash Brackman's house, not commit murder.
Objection.
Yes. I believe that those were not admitted.
Oh, okay.
Mr. Beck, you haven't been sequestered during this trial. Can you tell us what Alex Cifuentes said about the text messages under oath here?
Yes, Alex Cifuentes did testify that Avery Becker was planning to trash Brackman's house and not to murder it. So step 8 is Avery Becker.
Thank you, Your Honor. I have no further questions for this witness at this time.
All right, cross-examination?
Yes, Your Honor. Before we begin, may I have a time check?
Timekeepers?
Thank you. Good morning, Ms. Kuzak.
Good morning.
I'd like to start off by talking about the steps that you took in your investigation. You visited the crime at 444 South Flower Street.
I did.
And this was after it had already been processed and examined.
That is correct.
And you stated in your testimony that you would have preferred to have more physical evidence of the scene in order to have a more adequate investigation.
I did. And that's always the case in my line of work because the more evidence, the merrier, really.
Thank you, Ms. Kuzak. So your investigation is not as adequate as it could have been had you had that evidence.
I really hold myself to a high standard when it comes to my investigation.
So, Ms. Kuzak, for the jury, is that a yes? It is not as adequate as it could have been had you had that evidence.
What evidence are you referring to?
More physical evidence of the scene.
Well, in theory, I would always love more evidence, so yes.
Thank you, Ms. Kuzak. So you didn't see the crime scene exactly the way that it was left by the intruder after the crime was committed.
That is that is not necessarily correct. Are you suggesting that the police altered the crime scene?
You didn't see it the way that it was left by the intruder after the crime was committed.
I don't understand. The police were the ones who got there before me. So unless they altered it, the crime scene was exactly as it was left by after the incident occurred.
I'd like to talk about the photographs that were also crucial in your investigation. Now, there were more files than what we have present in court today, but these files were corrupted.
Yes.
And they were corrupted after your time of review.
Yes, that is correct.
So fortunately, you had no problem processing them for your analysis.
Fortunately, I was able to see those photographs of the blood spatter. Yes.
Thank you. And you also assume that every case will go to court?
I do, yes.
And you still chose to include this evidence in your court statement?
Well, it was important evidence that led me to my conclusion.
And you chose to include this important evidence, knowing that it fully well that it wouldn't be available for jurors to see today.
Conclusion?
One moment. That question actually broke up a bit, so I did not hear what the question was. I would like to rehear the question and then the objection.
Your Honor, my question for this witness was that she still chose to include this important evidence, knowing fully well that it wouldn't be available for jurors to see, as she was able to change and alter her testimony up until today.
May I respond, Your Honor?
Yes.
This calls for a legal conclusion in the fact that the crux of this question is Article 10 of the Rules of Evidence. Now, Article 10 states that there must be a requirement of an original. That is why I am not choosing to elicit testimony about the blood splatter, and that is not something Ms. Kuzak had control over, and therefore this question calls for Ms. Kuzak's legal conclusion on whether or not those documents would have been able to have been presented to the court.
Yeah. Prosecution, I do agree with your objection. I feel like this goes beyond the scope of your direct examination because you did not discuss the blood spatter. So I am going to sustain.
Yes, Your Honor. Move to strike the question from the record?
So done.
Yes, Your Honor.
Defense, you may continue.
Thank you. Ms. Kuzak, did you review photos of a stab wound on the victim?
Yes, I did.
And it is conclusive that this victim was presumably stabbed with a knife.
The victim was stabbed with a knife.
If you saw a photo of this, would you recognize it?
I would.
Your Honor, I ask that Exhibit 4 be displayed for this witness.
All right, go ahead and show Exhibit 4.
Do you recognize this photograph, Ms. Kuzak?
I do.
And what is this photograph?
Well, that is Mr. Brackman with his stab wound on the floor.
Is this a true and accurate representation of the photographs that you reviewed of Mr. Brackman on the floor?
Yes, yes, it is.
Your Honor, I move to ask Exhibit 4 to be admitted into evidence.
Prosecution, your response.
Yes, Your Honor. I have two objections. One under Article 9, authenticity, and the second under Rule 403, needlessly cumulative. May I be heard on both?
Yes, go ahead.
Your Honor, proper foundation has not been laid as to who took this photo and when it was taken, and that is essential to understanding this photo. Furthermore, pursuant to Rule 403, this evidence is needlessly cumulative because the jury is already in possession of one photograph of Mackenzie Brackman's body, and adding another would be needlessly cumulative.
All right, defense, your response to both of those objections.
Your Honor, Ms. Kuzak has stated that she did review these photographs in her investigation and that they were police files. So I do not believe that they are speculative, and I do believe that the foundation has been laid under speculation. Upon that, I also do not believe that photographs of the victim in this case are cumulative, needlessly cumulative, as it is the victim, and it is important for the jury to be able to see the position of the victim as he was killed.
A brief response, Your Honor.
Brief response.
Your Honor, I did not object under speculation. I objected under Article 9, which is authenticity for admitted exhibits. I am not alleging that there is any speculation, simply that we currently don't have enough foundation to admit this exhibit. Furthermore, the position of the body is perfectly clear in Exhibit
1. I am going to, I'm just going to ask that you lay a little bit more foundation for this. I do think that an additional photograph can be relevant because every angle of this can be useful for the jury to help reconstruct what happened.
Yes, Your Honor.
Thank you, Your Honor. Ms. Kuzak, did you review this photograph in your investigation?
Yes, I did.
And was this photograph taken by Detective Markowitz?
I believe it was.
And to your knowledge, is this a true and accurate depiction of the photograph and of the victim at the time of Markowitz's finding him?
Yes.
Your Honor, I now move to admit Exhibit 4 into evidence.
I have no further objection, Your Honor.
All right, it is so admitted.
Thank you, Your Honor. Ms. Kuzak, I'd like you to look closely at the victim's hands for me. From what you can see, do you see any blood underneath the victim's hands aside from the blood pool?
Well, we cannot see the bottom of his hands in this photo.
But as far as we can see, maybe on the top hand, there is no blood around the hands or on the hands from what we can see.
Your Honor, I would object under Rule 403, misleading the jury. Ms. Kuzak just testified that you can't see under the victim's hands, therefore asking a question of, is there any blood on the hands? That is misleading the jury.
Defense, your response.
I don't believe I was asking Ms. Kuzak to mislead the jury, Your Honor, but rather to clarify for the jury, which is very important in her testimony.
All right, I am going to go ahead here and defer to Ms. Cusack's expert experience on this. And I will I will allow the question.
Yes, Your Honor.
Thank you. May I repeat my question, Your Honor?
Yes.
So Ms. Cusack, you cannot see any blood on or around the hands from this photograph.
That is incorrect. We only have a partial view of the hands in this photograph. We can only see the top side of the hands. Therefore, I cannot testify today that there is no blood on or around the hands.
Thank you, Ms. Cusack. Now, if I showed you a photograph of the knife, would you recognize it?
Yes, I would.
Your Honor, I ask that Exhibit 6 be displayed for the witness.
Yes.
Do you recognize this photograph, Ms. Cusack?
Yes, I do.
What is this photograph?
That is the knife that was used to stab Mr. Brackman.
And where did you receive this photograph from in your investigation?
Well, this was taken by the police department, and
This was taken by Detective Markowitz, is that correct?
Who is a member of the police department.
Thank you. Is this a true and accurate photo of the knife found on 444 South Flower Street?
Yes, yes, it is.
And this is a photograph of the presumed murder weapon?
Yes, it is.
I now ask that Exhibit 6 be admitted into evidence, Your Honor.
I have no objection, Your Honor.
All right, then it is so admitted.
Thank you, Your Honor. Ms. Cusack, you see the measurements on the bottom of the picture of the knife.
Yes, I do.
And without counting each and every one, the total ruler goes up to about 21 centimeters.
Yes, it does.
So doing some basic geometry, we can assume that this knife is at least 21 centimeters long. Is that correct?
That is correct.
And you see the blood on the handle?
I do see the blood on the handle.
And in your statement, you concluded that Mackenzie Brackman pulled the blade out himself.
Yes.
But in your direct, you stated that it was an awkward angle.
Not in this context. What I meant was that what I was testifying to was that he could not have stabbed himself from that awkward angle.
Thank you, Ms. Cusack. Your Honor, I ask that Exhibit 19 be shown to the witness.
Go ahead.
Ms. Cusack, do you recognize this document?
Yes, I do.
And what is this document?
This is the medical examination autopsy of Mr. Brackman.
And is, from your knowledge, is this a true and accurate copy of the autopsy of Mackenzie Brackman?
While it appears a little bit blurry, it does appear to be accurate.
Thank you. Your Honor, I now ask that Exhibit 19 be admitted into evidence.
Prosecution, your response?
Your Honor, I object under Rule 802 hearsay.
Defense, your response?
Your Honor, this is an exception under Rule 8034, statement made for medical diagnosis or treatment. This is a medical statement regarding Mackenzie Brackman's body after the time of his death.
May I respond, Your Honor?
Yes.
Proper foundation has not yet been laid to allow an exception under Rule 8034. No specific testimony has been offered that this does contain a medical diagnosis or treatment. It just says that it contains medical information, and that is not the same.
Defense, is there another exception that you would like to find this under?
No, Your Honor, but I do believe that as it is an autopsy, it is implied that there is medical diagnosis within the document.
May I respond, Your Honor?
Briefly.
Unfortunately, implications don't hold up in a legal setting considering rules of evidence. I would ask that specific testimony be elicited.
Specific testimony be elicited?
Yes, specific foundational testimony.
Yes, I will agree with that. And defense, if you can lay a little bit more foundation on this, then we can see about admitting it.
Thank you, Your Honor. So, Ms. Cusack, this is the autopsy of Mackenzie Brackman.
Yes, it appears so.
And autopsies contain medical information and diagnoses from after a person's death. Is that correct?
Yes, that is correct.
And there is no reason to believe that this autopsy is false.
I have no reason to believe that.
Your Honor, I now ask that Exhibit 19 be admitted into evidence.
I have no further objection, Your Honor.
All right. I believe that sufficient foundation has been laid for this, so I am going to allow it to be admitted.
Thank you. Now, please refer to the section near the bottom of the second page titled Skeletal System. Ms. Kuzak, I know you may not be able to read for the blurriness, but I'm assuming that you have a copy with you as well. The first line states, remarkable for a small 2 millimeter indentation along the inferior edge.
Your Honor. This is
yes.
objection. I just worry that the jury won't be able to see through the blurriness. My timekeeper would be happy to project a non-blurry copy if opposing counsel wishes.
Yes. Please. I'd like to
Mr.
be able to
Trembach,
see
if you wouldn't mind. And I believe they were on page 2.
May I repeat my question, Your Honor?
Yes.
Please refer to the bottom of the section near the second page titled Skeletal System. The first line states, remarkable for a small 2 millimeter indentation along the inferior edge of the left scapula. Is that correct, Ms. Kuzak?
That is correct.
And please look to the second page of the exhibit and find the description of injuries portion near the top of the page. The third line states, depth of the wound is at least 19 centimeters deep. Is that correct?
That is correct.
So according to this autopsy, the wound is at least 19 centimeters deep.
Yes.
And you recognize that the knife had made a cut into his aorta?
It ended up nicking his aorta.
And the force of the blood pushing out from the aorta is what caused him to bleed out so quickly.
Well, that was when he took the knife out of his back. That is what caused him to bleed out.
Yes. You believe that he died before his body even hit the ground.
Well, I believe he died when he took the knife out of his back.
Thank you. So it's understandable to assume from when he removed the knife that blood was gushing out of his back as soon as the knife was removed.
You know,
Ms. Kuzak, I would like a yes or no answer if that's possible.
I'm not a medical expert in this sense. And so I don't want to give inaccurate testimony about the timing of when blood comes out of one's back after an object has been removed from it. Given that I'm a crime scene investigator and not a doctor, I would rather not mislead the jury in this case.
Ms. Kuzak, you remember providing a statement in the matter?
Yes.
And you were aware that up until today, you were able to alter the statement in order to make it true and accurate?
Yes.
Do you have a copy of your statement with you?
Yes, I do.
Please refer to page 25, lines 144 through 146. You stated, as soon as the knife was...
Your Honor, under Rule 702, this calls for expert testimony. These technicalities make it a little bit tricky, so may I be heard to elaborate?
Yes.
Your Honor, Ms. Kuzak has been tendered as a crime scene reconstruction investigator expert with a subcategory of biological evidence. Now, biological evidence means blood on the floor, general event pathways of how someone could have died, and DNA evidence, fingerprints, that sort of evidence. Now, as Ms. Kuzak said, she's not a doctor, and therefore she doesn't want to mislead the jury, so this would be inadmissible expert opinion under Rule 702 and misleading the jury under Rule 703.
All right, defense, your response.
Your Honor, Ms. Kuzak has made a statement in court today that is inconsistent with her testimony that she has previously provided to counsel in this case. And therefore, in order for clarification for the jury, it is important that we know what Ms. Kuzak's correct opinion, expert opinion, is in this case on how the victim died.
May I respond, Your Honor?
Actually, real quick, I just want to ask for clarification on the statement that you are concerned with defense.
I am concerned with the statement, Your Honor, that blood was gushing out of the victim's knife as soon as it was removed, and that was what caused the death.
All right, and prosecution, you have a response to that?
Yes, Your Honor, I know the statement that defense is speaking about, and my witness has not said anything in contrary. She's merely said that she can't give that opinion that she wrote here in court today. Not all evidence contained within an affidavit is admissible.
All right, what I'm going to do is we have the autopsy report, and I believe that that speaks for itself, and we will defer to that with respect to the cause of death. I believe that Ms. Cusack is capable of testifying, about where the blood was, how it came out. But I think that this does call for improper testimony in an area for which she is not tendered.
Yes, Your Honor.
Your Honor, may I continue?
Yes.
As a crime scene reconstructionist, it is your job to help figure out how a victim was killed and died. Is that correct, Ms. Cusack?
That is correct.
And in your statement, you stated, as soon as the knife was removed, the victim would have started bleeding internally at an accelerated rate and would have died very quickly.
Your Honor, we just covered that this was inadmissible expert opinion.
Defense? Response?
If I may continue, Your Honor, I still believe that this testimony is inconsistent. And as Ms. Cusack has stated that how a victim is killed and how a victim has died, she just stated that that is within her expertise and it should be admissible.
Okay, prosecution, quickly.
She referred to the generalization, not the medical specifics.
One moment, it looks like we have time, according to the timekeeper.
Your Honor, if I may, that seems a little strange as we were just in an objection. I believe that I do have some time left from my direct that I would be happy to give to opposing counsel if necessary.
Yeah, Your Honor,
okay.
The time was at 36 seconds at the start of the objection.
Okay, I am going to go ahead and, does time pause for objections?
Yes, Your Honor.
Yes.
Okay, then yeah, we should be at pause time right now. So I'm going to go ahead and you may proceed with the objection. Looks like we have 36 seconds left for questioning. So you may proceed with your, please restate your objection, prosecution.
Yes, Your Honor, Your Honor, you just ruled that Ms. Cusack cannot testify to the medical specificities. Ms. Cusack herself said that she can testify to generally how and when someone died, not the medical specificities, and those are the opinions that opposing counsel is attempting to elicit.
Yes, I did just rule on this. Defense, you may ask questions with respect to reconstructing the crime scene. However, as I said, with respect to any medical testimony, we will defer to the autopsy report.
Thank you, Your Honor. May I continue my cross-examination?
Yes.
Ms. Cusack, when the victim removed the knife, blood came out.
Yes.
And this explains the blood on the knife handle in Exhibit 6.
It explains the blood that came out of the wound.
Thank you, Ms. Cusack. It does not explain the lack of blood on or around the victim's hands.
We do not know that there wasn't blood on the victim's
Thank you, Ms.
hands.
Cusack. Thank you.
The victim
Ms. Cusack, no further questions.
All right, no further questions. Prosecution, did you have time for a redirect? Or not redirect? Yes, redirect. This is your witness. Apologies, I got confused.
Brief time check.
Yes, what is the prosecution's time?
We have 1 minute and 19 seconds left for redirect.
All right, would you like to deliver a redirect?
Briefly, Your Honor.
Yes, go ahead.
Ms. Cusack, would you mind just finishing your last response to opposing counsel's question about blood on the hands?
Sure. I mean, I was just saying that in, I believe it was Exhibit 4, we cannot see the hands in totality, right? And especially since if we're talking about the blood on the handle of the knife, that refers to the bottom of the palm that would be gripping the knife. So therefore, since we cannot see the palms in this picture, we cannot make any assumptions about whether there was blood or no blood on those palms.
Can you also explain the difference between stabbing yourself and pulling out a knife?
Yes, stabbing yourself, it would take lots and lots of force. It would be nearly impossible. However, removing a knife, since that pathway has already been made into Mr. Brackman's flesh, it would take less strength to do that.
Thank you, Ms. Kuzak. Thank you, Your Honor. I have no further questions.
All right. Then Ms. Cusack, you may go ahead and return to your seat. Prosecution, any further witnesses?
No, Your Honor, the prosecution rests, although may I request a brief 5-minute pause before we proceed with the defense case?
Yes. Yes, granted.
Thank you, Your Honor.
So everyone take 5. We will reconvene at 11:09. All right, 60 seconds before we're back. All right, we are back in session. Is everybody here?
Yes, Your Honor, the prosecution is ready to proceed.
Defense?
If we could have one more moment to just ensure that all of our people are back, I would appreciate that. Perfect. Thank you, Your Honor. I believe we are ready to proceed.
All right, then give me just one moment. All right. Defense, you may proceed with your case in chief.
Thank you, Your Honor.
Yes, would you like to go ahead and call your first? Would you like to go ahead and call your first witness?
Yes. At this time, the defendant calls Blake Van Owen to the stand. Good morning, Professor Van Owen. Could you please state and spell your name for the court?
Yes, my name is Professor Blake Van Owen, V-A-N-O-W-E-N, and that says two separate words.
And we call you Professor. What did you do to earn that title?
Well, I actually teach a class at CU Denver on police practices and social justice.
And of course, in order to teach, you need a degree. Could you tell us about your education?
Yes, I have a master's degree in criminal justice from Ashford University.
And do you have any hands-on experience in investigation?
Yes, I do.
And have you ever been qualified as an expert witness before?
Yes, I have consulted on tens of dozens of cases where I've been verified as an expert in the areas of police practices, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
And where have you been qualified as an expert?
In the U.S. District Courts for New Mexico, Colorado, Nevada, along with many others.
Your Honor, at this time, I'd like to qualify Professor Van Owen as an expert in the field of law enforcement, specializing in crime scene reconstruction, cell tower analysis, and general police investigation tactics, and to be able to give opinions based upon this under Rule 702 and 703.
May I respond, Your Honor? I do have an
Yes,
objection.
please.
Your Honor, I would say that the field of law enforcement is much too large a field now. No foundation has been laid to show that Mr. Van Owens is in fact qualified to talk about TSA agents, which are a form of law enforcement. So I've just asked that that be narrowed. Now, I have no objection to Mr. Van Owens' qualification as to police procedure. I agree that he meets the bare minimum requirements listed under Rule 702. I would like to conduct a brief voir dire about call detail records.
All right, I will go ahead and allow the voir dire.
Good morning, Mr. Van Owens.
Good morning. And actually, it's professor to you.
Oh, do you have a PhD?
No, I have a master's degree and I am a teacher. If I had a PhD, you
Now,
would call
are
me
you
a doctor.
aware that University of Colorado requires their tenured professors to have PhDs?
No, that's why I'm an associate professor.
So forgive me for being a little bit old-fashioned, but I think I'll stick with Mr. if that's all right. Now, Mr. Van Owens, you don't mention any specific courses you take in CDR data?
No, although I do have 15 years of experience in the field and I have been verified as an expert in this field over a dozen times.
Yes or no? No specific classes?
No,
You have no specific training in CDR data?
other than a master's degree, no.
Your master's degree is in social justice?
Yes, criminal justice, actually.
Not CDR data?
No,
You don't name any specific cases where you've used CDR data.
no.
Thank you, Mr. Van Owens. Thank you, Your Honor. My objection stands. He is not qualified under Rule 702 to give expert opinions based on CDR data. Now, in order to give an expert opinion under Rule 702, a witness must have specialized skill, knowledge, experience, education, or training. Now, Mr. Van Owens has not testified about his skill, has not testified about his knowledge, has not testified about his specific case experience, has not testified about his training, and lastly, has not testified about his education due to CDR data.
All right then, defense, I am going to ask, before I tender him, is anything, do you want to lay a bit further foundation on his qualifications?
Yes, Your Honor. So, have you worked any other jobs in the past, Professor?
Yes, I first started my work in police practices when I joined the Aurora Police Force 15 years ago. After that, I left because I didn't agree with many of the policies they had in place. And then I went and I worked as a school research officer, a private security guard, and then I began teaching as an adjunct professor at the Community College of the Rockies. And then I got my master's degree from Ashford University, where I became an actual professor. And I started doing private investigations in my spare time, and I've been doing that for the last decade.
And lastly, while you have not had any specific training or classes in CDR data, you have still been qualified as an expert in these fields beforehand.
Yes, in nearly a dozen states.
Thank you. Your Honor, at this time, I would still like to qualify Professor Van Owen as an expert in the field of crime scene reconstruction, cell tower analysis, and finally, police investigation tactics, and still be able to give opinions based upon this under Rule 702 and 703.
Your Honor,
Yes, response.
the ruling of prior courts has no bearing on how you rule today, Your Honor.
Mhm. I am fully aware of that. So what I'm going to do is I'm going to go ahead and allow him to be tendered as an expert in police procedure. And what were the fields that you wish to tender him in again?
Police procedure, crime scene reconstruction, and cell tower analysis.
Okay, I am not going to tender him in cell tower analysis. Did you lay any specific foundation for crime scene reconstruction?
As he was a police officer and also teaches criminal justice, as well as had multiple experiences in the field of police procedures, I do believe that he has laid enough foundation to be qualified as a crime scene reconstructionist.
I am going to go ahead and allow it for this purpose because he does seem to have some extensive training in law enforcement procedure and all of that. So I will allow the crime scene reconstruction. I am not going to allow the CDR data, though.
Thank you, Your Honor.
Yes, Your Honor.
Prosecution, did you have something to say?
No, Your Honor.
Oh, all right then. Defense, you may proceed.
Thank you. Professor Van Owen, I would like to talk to you about the death of Mr. Brackman. Have you reviewed the investigation in this matter?
Yes, I have.
And who retained you for that task?
Avery Becker's defense team retained me to review the methodology and the theories of the prosecution.
What material did you review?
I have carefully examined the entire case, including exhibits 1 through 22 and the direct witness statements for Avery Becker, Taylor Perkins, Jordan Markowitz, and Kyle Huzek.
Now, correct me if I'm wrong, Professor, but one of those exhibits is your report that you created for this trial.
Yes, that is correct.
And that should be Exhibit 20, yes?
Yes, I believe so.
Your Honor, may Exhibit 20 be projected onto the screen?
Yes.
Now, Professor, do you recognize this exhibit?
Yes, yes, I do.
And what is it?
This is the report that I created for use in this case by the prosecution and the defense.
And this was created based upon your review of the evidence?
Yes, it's a regular practice of mine.
As you said, did you write this as part of your regularly conducted business activity as an expert and a private investigator?
Indeed.
And has it been kept as a part of the files?
Yes, yes, it has.
Honor, at this time, I move to admit Exhibit 20 into evidence.
Prosecution, your response.
Objection, Your Honor, under Rule 802 hearsay.
May I respond, Your Honor?
Yes, please.
Under the business record exception, or Rule 8036, this is an exception to hearsay because it is a record of an opinion created at the time that the opinion was formed, and it is also part of the business record.
May I respond, Your Honor?
Briefly.
Your Honor, if proper foundation has been laid for this hearsay exception, I have no objection. However, I may have missed the laying of the proper at or near the time, so I would just ask that that be clarified. Otherwise, I have no objection to the use of that exception.
You asked that what be clarified?
The at or near the time, please. Your Honor, that the record was created at or near the time when Mr. Van Owens was reviewing the data.
All right. Is there any, can you lay any foundation for the time at which this was created defense?
Yes, Your Honor. So, Professor Van Owen, after you were hired by the defense, did you review the evidence?
Yes, I reviewed all the evidence, and within the next few days, I actually created this report directly.
So you created this report as you were creating your opinion of the case, correct?
Yes, this is true.
Your Honor, at this time, I believe the foundation has been laid, and I move to admit Exhibit 20 into evidence.
Your Honor, I have no further objection. I would just ask that the last couple of pages, which do detail CDR data opinions, be constructively redacted.
Yes, I will allow that. We will constructively redact the data regarding CDR.
Yes, Your Honor.
Defense, you may proceed.
Thank you, Your Honor. All right, Professor. Your report is about 5 pages long. What points do you think are the most important?
First of all, I'd like to say that the prosecution actually managed to lose evidence. Secondly, they intentionally chose not to follow some of the basic police procedures. And finally, their entire investigation was heavily incompetent and heavily biased.
Now, did you review the prosecution crime scene reconstructionist Kyle Kuzak's conclusions and hear their testimony?
Yes, yes, I did.
And based upon your expertise and your review of the evidence, do you have any disagreements with the conclusions reached by Kyle Kuzak?
Yes, I would have to say I do.
Could you explain those disagreements?
First of all, I'd like to point out that I have worked out with Detective Markowitz in the past on different cases, and I'd like to say that Markowitz undoubtedly influenced some of Kuzak's findings.
Objection, Your Honor, speculation. And I would like to tender an offer of proof as well.
All right, can you restate the question, defense?
Yes, Your Honor, this was a question built upon my previous one. So this question is, please explain your disagreements. And the previous one was based upon your expertise of the review of the evidence. Do you have any disagreements with the conclusions reached by Kyle Kuzak?
All right, prosecution, would you like to explain your objection?
Yes, Your Honor. I have no objection to the questions asked. I simply have an objection to the testimony of the witness stating that Jordan Markowitz undoubtedly influenced the examination of Kyle Kuzak. Now, I plan to lay proper foundation on my cross-examination that will show you that this witness has not talked to Kyle Kuzak, has not talked to Jordan Markowitz. and they do not work especially closely together. Furthermore, this testimony asks about the mental state of Kyle Cusack, which is pure speculation.
All right, so I agree that you cannot speculate on the mental state of Kyle Cusack. I will reserve ruling regarding Detective Markowitz until after I hear your questions at cross-examination.
Yes, Your Honor.
Thank
Move
you,
to
Your Honor.
strike that little bit of testimony from the record.
Strike any testimony regarding the mental state. However, I will withhold striking regarding Detective Markowitz.
Yes, Your Honor.
Professor, would you like me to repeat my question?
Please and thank you.
Could you explain the disagreements you have between the conclusions reached by Kyle Cusack?
I agree that on-scene evidence points to an intruder that broke into the home of Mackenzie Brackman. However, this is the only thing that Cusack and I agreed upon. Cusack's scenarios are unsupported and unreasonable. The only actual apparent evidence of a struggle is a supposed scuff marks on the floor. However, we do not know when these scuff marks were made, and we do not know how the scuff marks were made. Additionally, the broken plate on the floor suggests that Brackman was actually caught by surprise. However, Cusack never seems to accept this as an opinion.
And what is your opinion of Cusack's analysis of the murder weapon?
Not only is the knife itself a completely different brand of murder weapon than every other blade in the knife block, it is also completely inconsistent in both dimensions and style with every other knife present in the building. The second problem is that Cusack guesses, without support, that the intruder was surprised by Brackman and during the struggle managed to wrestle the knife from the grips of Brackman and stab him in front of him in such a manner.
Now, before we move on, is there anything else about the wound or the knife that you think is important?
First of all, I'd like to say that there are, for the sake of time, I'm having to summarize much of this, and there are more details in my report if the jury would like to see it. Cusack essentially thinks that the intruder was in front of Brackman based on the position of the knife. However, for the blade to have been able to simultaneously manage to go downwards in such an angle and manage to pierce Brackman's aorta, the intruder would have been a much larger person, which we can disprove based off of the Ring doorbell footage.
Now let's talk about those Ring videos. Do you agree with Detective Markowitz's conclusions regarding those Ring videos?
No, I do not.
And could you explain your disagreements?
Markowitz makes a big deal about the Ring app alerting the victim to the intruder in advance. However, we don't actually have any evidence at all that tells us when these videos were taken. Every single detail we know about the videos comes directly from the mouth of Detective Markowitz, who is certainly not an expert in Ring doorbell footage analysis. Markowitz assumes that Brackman had notifications turned on, so that way he would be alerted when motion was detected, but we can't actually prove any of this because Markowitz failed to confirm any of this information with the Ring Doorbell Corporation.
Thank you, Professor. Now, moving on to the cell tower data, you reviewed this data, correct?
Objection, Your Honor. This has been ruled outside of this witness's expertise.
Yes, this was a question about the CDR, correct?
Yes, Your Honor.
Prosecution, do you have any response to that? Or defense, rather, do you have any response to that?
I believe since Professor Blake Van Allen has based part of his opinion on this data, he should still be able to testify to it, although he is still not an expert in the field.
Response, Your Honor.
I'm actually going to go ahead and sustain your objection, prosecution, because he has not been so tendered. So I think it would be improper for him to testify about it.
Move to strike the question from the record.
So struck.
Yes, Your Honor.
Thank you, Your Honor. Now, while listening to Detective Markowitz's testimony today, you heard that she stated that Avery Becker's phone was near Brackman's house on the day of the murder, correct?
This is correct.
And do you agree that this could have happened?
Objection, Your Honor. I hate to raise this objection again, but this is still CDR data evidence.
Prosecution, can you repeat the question once, or defense rather, can you repeat the question once more?
So my question was, if Professor Van Owen had listened to the testimony of Detective Markowitz in court today, and I asked him if he thought that Detective Markowitz's evaluation that Avery Becker's phone was near Brackman's house on the day of the murder was valid.
Yeah, because we've already ruled on this, he cannot testify to the CDR data. So I'm going to strike that question.
Thank you, Your Honor. Now, are there any other factors that influence your opinion about the methodology used in this investigation, Professor?
Yes, the police actually managed to lose photographs illustrating their complete incompetence of the blood drops on the hallway and of the apparent cast-off on the wall. I don't know how often this is supposed to happen in cases. However, file corruption in a police force seems a little sketchy to me.
And as someone who has worked for years in the field of law enforcement and have been qualified as an expert in the field of general police practices and also crime scene reconstruction, what is your opinion of the methodology used in this investigation overall?
As a whole, their entire investigation was rushed. Markowitz decided Becker was guilty at the beginning and only looked at evidence which would support that conclusion. As a whole, their entire investigation was totally incompetent and biased.
Thank you, Your Honor. No further questions for this witness.
All right, prosecution, would you like to cross-examine it?
Yes, Your Honor. I may have one moment. I have a medical condition regarding my feet, and so I took off my shoes and I need to put them back on. My apologies.
All right, yes.
Okay. I'm ready to proceed, Your Honor.
All right, go ahead.
Good morning. Again, Mr. Van Owens. I'd like to just lay a brief bit of foundation at what you looked at in terms of this case, if that's all right.
Yes, that's acceptable.
Now, you never went to the scene.
No, because I was hired afterwards.
That means you never saw Mackenzie Brackman's kitchen.
No, I was only given the evidence that was provided to me by the prosecution.
You never saw his patio.
No,
You never saw where the body was.
I did actually, based off of the video of the photographs.
But not in person.
Not in person, no.
And you didn't see the knife drawer in person.
No.
You didn't measure the knife block in person.
No, I did not.
You didn't look at the Ring camera yourself in person.
No.
I'd like to shift now to who you spoke with in this case.
Yes, certainly.
Now, you never spoke with Jordan Markowitz.
No, I did not.
You never spoke with Kyle Kuzak.
Mm-mm.
You never spoke with Alex Fuentes.
No, I did not have the opportunity.
The only two witnesses you spoke with were the defendant
Yes.
and the defendant's best friend.
Yes.
Now, I'd like to move on to...
One moment, prosecution. Would you like to clarify as to the best friend?
Oh, yes, Your Honor. Taylor Perkins.
All right. Proceed.
Mr. Van Owens, you never spoke with Taylor Perkins?
No, I did not.
I'd like to move on to records that you don't have. You never downloaded the contents of Avery Becker's phone.
No, I did not. However, if you might permit me to say something, by listing all the things I was not given access to, you are only undermining your own evidence.
Your Honor, strike that testimony as argumentative.
It is argumentative. However, I will not strike it.
Yes, Your Honor. Mr. Van Owens, you would only respond with yes or no. Yes or no, you never downloaded the contents of Taylor Perkins' phone.
No, given the fact that I was not given the opportunity to.
Taylor Perkins, the witness that talked to you,
Yes.
the witness that came to you,
Yes.
the witness that you could have asked for her phone records,
Yes.
but you never asked,
No, I did not.
even though Taylor's the main alibi witness.
Hmm.
And you could have confirmed Avery Becker's alibi.
I could have if I had been verified as an expert in the field of cell tower analysis.
Now, let me say something on this. This has no bearing. You view yourself as qualified, right?
I certainly do, given the fact that I've spent
And
half
you
of my
think yourself
lifetime
qualified.
in this field.
You thinking yourself qualified could have downloaded those records. You could have asked for them,
Yes, I could have.
but you never asked for them.
No, I did not.
And now, I'd like to talk about other things you could have asked for, but you don't bring. You heard the defense's opening statement.
Yes, I did.
You heard them talk about someone with possible more motive.
Yes,
And that person is Blair Rowlands, you think.
yes,
Now, you came up with the idea of Blair Rowlands after Avery told you about Blair Rowlands.
Objection, Your Honor, relevance.
May I respond, Your Honor?
Yes.
Credibility of a witness is always relevant, as is outside influence, specifically when the defense alleges that the prosecution case was biased. The prosecution may allege that back at the defense.
May I respond, Your Honor?
Yes.
Your Honor, this is not relevant considering that Professor Van Owen today did not testify to Blair Rowlands in his direct. Not only this, it is not the burden of the burden of the defense to prove another witness or another murderer. It is simply ours to make the prosecution prove what they are required to prove.
May I respond, Your Honor?
Yes, briefly.
Now, every piece of evidence in opening came in under a good faith basis that it would be elicited in court. Therefore, that gives me the proper scope to cross-examine this witness as to that.
So that this Blair Rowlands has not been talked about before in this case, and you are asserting this as an alternate suspect. Do I understand this correctly?
Your Honor, if I may explain briefly, in the
Yes.
defense opening statement, they talked about someone with more motive than Avery Becker. Now, Van Owens did do a small investigation into this person, and there are facts that I would like from this witness about that small investigation to disprove the existence of someone with a greater motive. Now, any statements in opening are admitted in opening under a good faith basis that they will be allowed, and that they will come in during trial. Normally, if this was an actual trial, I'd be able to recall this witness as a rebuttal witness, but unfortunately, due to the time constraints of mock trial, I'm not allowed to do that.
All right. I am curious to see where you're going with this, and how this will affect the case. So I am actually going to allow this line of questioning.
Yes, Your Honor. Now, Mr. Van Owens, you've never met Blair Rowlands.
no. And the main reason that I actually did this investigation was to prove the fact that the police never actually bothered to investigate anyone other than Avery Becker.
You didn't investigate anyone other than Avery Becker.
Well, actually, I investigated Blair Rowlands, as you have just said.
You don't present any court records about your investigation of Blair Rowlands.
No, I do not.
Thank you. Now, I'd like to move on to your insistence that the prosecution's investigation was rushed.
Yes, it was indeed.
You're being paid for this case,
Yes, roughly $7,000 to date.
and you make $225 an hour.
Yes, and $450 for in-person court hearings.
Your Honor, I would like the court to take judicial notice that 7,000 divided by 225 is approximately 31.
All right. And what is the point you're trying to make with this?
If you would give me a little more leeway, since he makes $225 an hour and has been paid $7,000, that division shows how many hours he's worked, which is 31, which is just under a day and a half.
You're assuming that I do this as my main job. Keep in mind that I work as a teacher full-time and I work as a private investigator in my hours off, which can roughly equal 2 hours a day maximum. So by doing that, you have to assume that I've spent at least 3 weeks worth of my time on this case.
Now, Mr. Van Owens.
First off, I would like to request that the witness do not speak unprompted. I would like to see where your line of questioning is going, prosecution, but I'd like you to keep it brief.
Yes, Your Honor. You worked on this case for 31 hours.
Yes.
A little bit less than a day.
A little bit more than a day, actually.
A little bit more than a day. My apologies, Mr. Van Owens. Thank you, Your Honor. I have no further questions for this witness at this time.
All right, defense redirect.
No, Your Honor.
All right, then, Mr. Van Owens, you may take a seat and we will allow a moment for our timekeepers to reconcile their clocks.
Yes, Your Honor.
And then defense, you may call your next witness. Timekeepers, are your clocks reconciled?
Not yet, Your Honor. I'm trying to type it into the chat.
All right.
Your Honor, and everyone present, I'm going to suggest that in the interest of time, we do not continue stopping the clocks when exhibits are in the process of being exhibited on the screen. I'm going to recommend that we continue with the timer.
Okay. Oh, there does seem to be a
Your
relatively
Honor, if I
large
may?
discrepancy. Yes.
I believe that if we do not allow for time for the defense case, I do believe that is a bit unfair, that the prosecution was allowed this extra time where the defense would not be allowed this time for the last two witnesses.
Court monitor, your opinion?
That seems fair to Grace's point. But do keep in mind this group is quite a bit behind.
Okay, then. I will ask everyone that we speed this up a bit. But yes, in the interest of fairness, we will still do that.
Thank you. In the interest of time, we will try to keep our directs brief.
All right, thank you. And we will go ahead. You may call your next witness.
Thank you, Your Honor. The defense now calls Taylor Perkins to the stand.
Your Honor, my apologies. A very quick pause. My co-counsel has been kicked out of the Zoom, and I'm wondering if you would mind letting her back in.
Oh, I am not the host.
Oh, it appears she's back in. Thank you so much. My apologies for the interruption.
All right.
The defense now calls Taylor Perkins to the stand.
Ms. Perkins, will you please state your name and spell your last name?
Yes, my name is Taylor Perkins, Perkins.
Thank you, Ms. Perkins. I'd like to start off by talking about your relationship to this case. Were you a student at Colorado High School last year?
Yes, I graduated from Colorado High School last year.
And did you know Mackenzie Brackman?
Yes, Mackenzie Brackman was my mock trial coach.
And did you know Avery Becker?
Of course, Avery was my best friend in high school.
And do you also know Alex Fuentes?
Yes, Alex was on the team with us.
Thank you. I'd like to discuss your time on the mock trial team. How would you describe mock trial during your senior year?
I mean, it was fine. I only joined because Avery joined and I wanted to hang out with my friend more. But there was definitely tension on the team, like between Avery and Coach Brockman. I think one of the bigger issues, though, was between Alex and Avery.
From your observations, what kind of issues did Becker and Cifuentes have on this team?
Well, Avery was naturally talented at mock trial, and it was kind of obvious that Alex would get jealous of the positions that Avery or the roles that Avery would play on our mock trial team.
Now I'd like to talk about the night before the day in question. Was Mr. Becker kicked off the mock trial team?
Yes, Avery was kicked off the team.
And what happened after Mr. Becker was kicked off the mock trial team?
So Avery went back to Coach Brockman to try to get back on the team. However, he was unfortunately turned away. So then as a friend, I consoled Avery and we hung out and we went and got food at Fry Shack. And then I remember a bunch of the mock trial team showing up and they were all talking about how bad they felt about Avery getting kicked off. And even Alex was saying how bad he felt, which seemed super insincere because Alex and Avery were never close. But then Avery got super upset with everybody talking about how bad they felt and talking about the whole situation in general and stormed off to the bathroom, leaving his phone on the table, which was super, super weird because that thing is like his third kidney.
And what happened after Mr. Becker came back from the bathroom?
Well, Alex and I were the only two left sitting at the table, and I, of course, no longer wanted to be sitting there because Alex was being super insincere and kind of a passive-aggressive way like normal. So Avery and I got up and left pretty quickly after he returned from the bathroom, and I'm pretty sure Avery left his phone on the table.
Ms. Perkins, how did you feel?
Lack of personal knowledge.
All right, defense, your response?
If I may, Your Honor, the witness has already answered the question, and so it's too late for the objection, and we are prepared to move on to the next question.
Response, Your Honor.
Quickly.
As I make an objection, if it is sustained, I'm asked that the previous testimony be stricken from the record, so therefore it is not too late to object to previous testimony.
And I do want to hear your response to lack of personal knowledge. Quickly, defense.
Your Honor, Ms. Perkins has stated that she was at the Fry Shack with Avery the night before the murder, and she can testify to her own personal observations from her 5 senses based on what happened the night of the Fry Shack. And I do not believe that her testimony is outside of this.
I agree with you, defense, so I'm going to overrule the objection.
Thank you, Your Honor. Ms. Perkins, how did you feel about being on the mock trial team at this point?
I only joined because Avery did, like I said before, so I didn't feel a whole lot of connection to it. And since Avery had gotten kicked off, I quit.
Now I'd like to discuss the day in question, March 6, 2020. What happened in the morning, March 6th?
So that morning when Avery and I got to school, we realized that Avery's phone was missing. And so we had already taken our senior lit test. And so the rest of the classes of the day didn't really matter. So we decided to skip school and we went to look for Avery's phone because it was super important to him. And we retraced our steps from the day before. So we began at the mall and we went to every single store using my phone to text and call to try to like hear the sound to find the phone. And then we ended up at Fry Shack because we had also been there the prior day.
Did anything happen to you and Mr. Becker while you were at Fry Shack?
Yeah, I remember a bunch of the team showing up, the mock trial team that is, which was super, super weird because they should have been at practice.
Did your teammates talk to you while you were there?
Yeah, they were telling us all about how Coach Brockman didn't show up. And even weirder, he wasn't responding to any text messages or calls that they were sending.
And Ms. Perkins, how did you feel when you heard this?
Well, at first I didn't think anything of it, but then I realized later in reflection how weird it was that we were talking about Coach Brockman while he was laying on the floor, possibly dead.
Was Mr. Becker with you while you were talking with your teammates?
Yeah, Avery was with me the whole day. You could see my phone records to see where we went that whole day.
And for the record, were you ever approached regarding your whereabouts on March 6, 2020?
No, nobody ever asked me about where we went or for my phone records to prove that.
And were you ever approached regarding your cell phone data on the date March 6, 2020?
I was not.
Thank you. Your Honor, no further questions.
All right, prosecution, your cross-examination.
Yes, Your Honor. Ms. Perkins, you know Mr. Becker quite well.
Yeah, Avery's my best friend.
You joined mock trial to be with Avery.
I did.
You spent a lot of time with Avery on mock trial.
Yes, we spent a lot of time together in general. We were best friends.
You knew that Avery didn't like Brackman.
I, from outside observation, could see that they had some disagreement.
They would fight.
Occasionally, they would argue, yes.
Those arguments would escalate.
I suppose.
Brackman would yell at Avery.
Yes, Coach Brackman would raise concern.
And Avery would yell back.
I think that depends situationally, moment to moment.
But you observed on multiple occasions that Avery would yell back.
I think like any teenager, Avery could have a temper in some moments.
On one of these occasions, Avery got particularly heated and Brackman demoted Avery down to the B team.
Yes, that did happen.
And when that happened, Avery was angry.
Of course, like any student would be.
So he called you.
Yes.
You talked about it.
Like any best friend, we kept up with each other's lives.
Right. And like any best friend, you decided to step down from the team for Avery.
Again, like I said before, I didn't feel much connection to the team anymore. And I did believe that Avery deserved that A-team spot, so I stepped down.
You sacrificed your position on the team so that Avery could have his back.
I wouldn't call it much of a sacrifice for me.
Now, Ms. Perkins, let's talk about the day before Brackman was killed. You and Avery had gone to the Fry Shack.
Yes, we did.
But you left the Fry Shack because Avery felt angry.
Yes, after Avery de-escalated when he went to the bathroom, we had left.
Right, Avery was angry because he saw the rest of the team.
Avery was upset because people were talking a little too much and belaboring the topic of him being kicked off.
Right. Avery had just been kicked off the mock trial team.
Yes.
Let's talk about how that happened. Avery and Brackman had another fight after Avery was let back on 18.
Yes, they argued.
This happened after the regional tournament.
Yeah.
Now, Avery took a marker and went outside.
Yes, which he originally thought was a dry erase marker.
Right. Brought the Sharpie down on the hood of Brackman's car and vandalized it.
Like
Objection,
I said,
Your Honor, relevance.
Prosecution response.
Your Honor, the evidence of Ms. Becker's previous crime is obviously relevant to this case because it shows motive to vandalize. However, there's further relevance as to how this witness knows of this vandalization, and rather what she does not know of this vandalization is what I'm going to elicit.
Yeah, because we've already allowed this information in, I'm going to go ahead and overrule the objection and allow you to ask questions on it.
Thank you, Your Honor. Now, Ms. Perkins, Mr. Becker brought the Sharpie down on the hood of Coach Brackman's car and vandalized it.
he thought that it wouldn't be vandalism in the first place. That was not his intent to damage permanently, because he originally thought that it was a dry erase marker.
Now, you know all of this because Avery told you.
Like I said before, we were best friends. We kept up.
You weren't there.
No, I was not in that moment.
Now, Mr. Becker told you that he made a mistake.
Of course.
But Mr. Becker said the mistake was using a Sharpie instead of a dry erase marker.
Yes, that was a pretty large mistake, and he originally thought it was a dry erase marker.
But Mr. Becker never said that he felt regret.
I think that came through in him telling me that it was a mistake.
But he said it was a mistake that he used a Sharpie instead of a dry erase marker.
I think that it was a harmless prank and he had no intent to vandalize, knowing or previously assuming that it was a dry erase marker.
Even so, Ms. Perkins, yes or no, Avery Becker never told you that he felt regret.
Again,
Your Honor, asked and answered.
Yeah, I'm going to sustain that objection.
Yes, Your Honor. Ms. Perkins, let's talk about the day that Brackman was killed. You and Avery were going to drive to school together.
Yes.
But you decided to skip school.
We had already covered our responsibilities, like I had said before.
You skipped school that day to look for Avery's phone.
We did. We skipped the rest of the day to look for Avery's phone.
You claim that you went to the mall in the morning.
That is where we were tracking his phone, again, using mine to text and call.
But earlier in your direct examination, you said you saw Avery lose his phone at the Fry Shack.
Yes, I do believe that looking back in reflection, I was thinking about where he could have possibly left it, and it is possible that he left it on the table at the Fry Shack when we left the night before.
But you looked at the mall first.
Yes, again, in the moment, it could have been anywhere. I said in reflection to the past events, I decided that it could have been on the table.
You texted and called Avery's phone multiple times that day.
Yes, we did.
But you never used the Find My iPhone app to track it.
Objection, Your Honor, outside the scope of the witness statement.
Response, Your Honor.
Yes.
The witness can testify to whether or not they used a tracking device to track Mr. Becker's phone on the day that it was lost.
I will allow the general question of whether or not you used any tracking information.
Again, Ms. Perkins, you didn't use any tracking device to find Mr. Becker's phone.
While I'm not an expert in Find My iPhone, the app that you brought up, I do know how it works, and the other phone has to be set up with Find My iPhone, and I'm not positive whether or not that was, and we didn't discuss that.
In your witness statement, you said that you forgot that you could use it.
Like I just said, we never discussed it, and in reflection, yes, I forgot that we could have used it.
Now, Ms. Perkins, before you came to this case today, you were contacted by Avery Becker's attorneys.
Yes.
And promptly after that, you called Mr. Becker.
Like any teenager would, I was pretty shocked about what I had heard, and I wanted to talk to my best friend.
In that phone call, Avery told you that Alex Cifuentes could be involved.
Yes.
Avery told you that Blair Rollins could be involved.
Yes, those names were brought up. They were friends in high school.
Avery told you that Alex Cifuentes had fake text messages.
Objection, Your Honor, hearsay.
Response, Your Honor.
Yes, response.
Pursuant to Rule 801 D2A, all statements made by Avery Becker are opposing party statements and are therefore not hearsay.
Yes, I agree with that. So I will overrule the objection.
Ms. Perkins, one more time, Avery Becker told you that Alex Cifuentes had fake text messages.
Avery had mentioned that that was a possibility, yes.
Before that, you hadn't even considered that Blair would be a suspect.
I don't think I spent much time thinking about who could have possibly murdered my mock trial coach, no.
Not in a million years would you have considered Blair.
I suppose.
Now, let's talk about your phones. You and Avery play on your phones frequently.
Like any teenager.
You even played on your phones on the night of March 5th.
Yes, we did.
You say Avery's phone is like his third kidney.
It is.
But you don't find it coincidental that on the day of Brackman's murder, Avery lost his phone.
I believe he lost his phone the night before, not the day of the murder.
Ms. Perkins, on that phone call with Avery Becker, Avery told you to say that you were at the mall.
I'm sorry, I don't understand your question.
Objection, Your Honor, outside the scope of the witness statement.
Response, Your Honor.
Response.
Your Honor, this witness may testify to whether or not Avery told her, to what Avery told her.
All right, I will allow this question.
Ms. Perkins, after you were contacted by Avery Becker's lawyers and you called Avery, Avery told you to say that you were at the mall on March 6th.
I do not believe so. Avery and I just discussed what the situation was, and he did mention Blair Rollins and Alex Cifuentes. However, he didn't tell me specifically what to say. I am my own human and can decide what to say.
Ms. Perkins, thank you, Your Honor. I have no further questions for the witness at this time.
All right, defense, would you like to redirect?
No, Your Honor.
All right, then, Ms. Perkins, you may take a seat And defense, would you like to go ahead and call your next witness?
Yes, Your Honor. At this time, the defense calls Avery Becker to the stand.
All right, Mr. Becker, would you please say your name and spell your last name?
Avery Becker, Beckerer.
All right, defense, you may proceed with your examination.
Thank you, Your Honor. Good morning, Mr. Becker, or
Good morning.
afternoon. I would like to start by speaking about school. Did you attend high school?
Yes, I went to Colorado High School, or I still go to CU, but I did go to Colorado High School.
Did you do any after-school activities in high school?
Well, I did this little club called Mock Trial.
What is mock trial?
Well, basically, you've got a lawyer and a witness, and obviously the lawyer questions the witness. It's kind of like you're in a courtroom, but obviously you're still in high school.
Now, did you know Mackenzie Brockman?
I did, yeah. It's quite sad about what happened.
Were you and did you and Mr. Brackman get along?
No, we really didn't, honestly.
Now, coming back to mock trial, was that a competitive club at all?
Well, it is competitive in the sense that we do compete against other teams and go to regionals and then state in the nationals if we're good enough.
Did you go to regionals last year?
Yeah, everyone goes to regionals no matter what.
And what happened after regionals last year?
Well, Mr. Brackman always used to like to have our teammates critique ourselves, and by doing that, he has like random people go up to the whiteboard to write on the board and critique. And he chose me, and he, instead of critiquing me, he kept insulting me instead. So with the marker that I still had in my hand, which I thought was a dry erase marker, I left because nobody wants to be insulted. And then as I was leaving, I saw Brackman's car, and I wrote on his car with the marker, Worst Attorney Award, thinking that it was going to wipe off because I had a dry erase marker in my hand. But right after, I realized that it was a permanent marker, and I realized like the full scope of what I did, and the guilt immediately like took me. And I haven't stopped feeling the guilt to this day.
Now, did Mr. Brackman ever find out about what happened to his car?
Yeah, he caught me in the act, actually.
And what did he do when he found out?
Well, he kind of blew up on me, meaning like he got really mad, yelling, everything like that, and he kicked me off the team, which I thought was a appropriate punishment for what I did.
Did you get a chance to speak to Mr. Brackman after he removed you from the team?
No. So the next day, actually, I tried going to his office at his law firm, but his secretary said he was either busy or didn't want to talk. And then I proceeded to text him because that's the only way I knew how to get a hold of him at the time. Well, not at the time, just in general. And basically I detailed how I would clean all of the marker off his car because I shouldn't have done it in the first place. And then get a summer job to pay for a whole new paint job for his beautiful Porsche.
Can you describe your relationship with Mr. Brackman after all of this happened?
Well, I mean, after all it happened, he was pretty mad at me, so it wasn't the best.
Let's talk about some of your teammates. Did you have any friends on the club?
Well, I had my best friend, Taylor Perkins. She's amazing. Most of us were pretty good friends, except for Alex Cifuentes. I didn't really look. I guess he's.
Who's Alex Cifuentes?
Well, he's this teammate on our team. He kind of seemed like a lone wolf, I guess. He also seemed insecure of me because I'm an award-winning attorney and witness and closer. And he wanted that.
Can you tell us a little bit more about your perception of your relationship with Mr. Cifuentes?
Well, again, as I just said, he seemed insecure, and he also seemed jealous of what I had.
Have you ever asked Mr. Cifuentes for help?
No, and I never would in a million years.
Have you ever texted Mr. Cifuentes?
I haven't, ever.
Finally, I'd like to speak with you about the day of March 6th. Are you aware of what happened on that day?
Yeah, Mr. Brackman was found dead. Apparently, he was murdered.
Where were you on March 6th?
Well, I was with my best friend Taylor. We were kind of traversing the mall area in the Fry Shack for my phone, which I lost the night before on March 5th.
Can you explain once more, why did you go to the Fry Shack?
Well, because that's where we think we lost my phone. We actually still haven't found my phone to this day.
And finally, Mr. Becker, were you with Miss Perkins the entire day of the crime?
Yes, I was. We were texting and calling my phone from her phone. So there is record of that too.
Thank you, Your Honor. No further questions for this witness.
All right, prosecution, cross-examination.
Yes, Your Honor. Permission to proceed?
Yes.
Good evening, Mr. Becker. I'm going to ask you a few questions.
Good afternoon.
Good afternoon. You love mock trial.
Yeah, I was amazing at it.
It meant everything to you.
Again, I was amazing at it, so of course.
You were amazing at it.
Well, I won a bunch of awards.
But Mr. Brackman still demoted you to B team.
Well, in the club, it was basically his way or the highway, and I chose the highway, so I got booted.
It frustrated you that you got booted.
Yeah, of course, I'm great at mock trial.
Later, you were brought up to A team.
I was, and I won a couple more awards.
However, that still didn't change your opinion of Mr. Brackman, did it?
No, while I respected him immensely, he still didn't really like me.
You basically ignored Coach Brackman's comments.
I guess I did.
Because you claimed that you were so good at just making things up on the fly.
Well, he made scripts for everyone, and I didn't really agree with those. I agreed with my own scripts.
You saw that ignoring his scripts frustrated him, correct?
It did frustrate him because, again, his way or the highway.
And after regionals, Mr. Brackman criticized you for your performance.
Yeah, I mean, he did say that I relied on my good looks, so he complimented me there.
Here, you couldn't take the criticism.
Well, nobody likes to be insulted, so yeah.
You called him the worst coach in the state.
That did come out of my mouth.
You ran out to his car.
Well, I left and I saw his car, actually.
In the middle of the day.
His car was on the way to mine.
You wrote worst attorney award on his car.
I did write that. I'm not denying it.
On his Porsche.
On his Porsche, just a car.
On his, I would like you to keep your responses to a yes or no answer. Thank you. On his private property.
I just wrote on his car.
His car is his private property.
I guess so. I don't really know the laws.
This time he kicked you off the team.
He did, and I thought it was appropriate punishment for what I did.
He refused to let you back on.
Again, appropriate punishment.
Now, on direct examination, you claim that you felt guilty immediately after that happened. Is that correct?
Well, of course. I don't think I should have done it in the first place.
Now, you wrote a witness statement for this court today, correct?
I did.
I ask the timer to please screen share a copy of what has been previously marked as Avery Becker's witness statement. Now, you agreed to make any changes to your witness statement if anything changed, correct?
Yes.
And this is a fair and accurate depiction of your witness statement?
Yeah, it is.
I would like you to read along silently as I read aloud. Starting on line 100. You're off the team. You can join that loser Taylor Perkins and play video games all the time. That made me even madder. I went home and told my mom that Brackman got on me again for no good reason and I had walked out of practice. I didn't tell her what I had done to his car. I said he had followed me out to practice and got even madder at me and kicked me off the team. I told her I would get back at him if it was the last thing I did. Did I read that correctly, Mr. Becker?
Yes, but again, I was in a fit of rage. I wasn't ever planning to follow through with what I was saying.
You were in a fit of rage.
Yeah, I was.
But nowhere in there does it say that you felt guilty immediately after you vandalized Mr. Brackman's car, did it?
No, it didn't. Upon further reflection after the event, that's when I realized it. The fit of rage was just like so overtaking.
Timer, you are able to take down Mr. Becker's statement. Thank you. So you told your mom that you would get back at Mr. Brackman if it was the last thing you did.
Yes, but again, I was never intending to follow through with it. And plus, I would never want to cause Brackman more pain, ever.
Please keep your responses to a yes or no response. You said the same thing to Alex.
Can you repeat that, please?
You said the same thing to Alex.
The same thing as referring to what?
The statement you made towards your mom.
Objection, Your Honor. Speculation and lack of foundation.
Response, Your Honor?
Yes.
Asking a question about a statement that the witness made themselves is not speculation because it is concerning a statement that the witness made. Therefore, the witness is able to testify to their own perception.
Yeah, I'm going to overrule that objection.
Thank you, Your Honor.
However, to move on, you claim that you were at the mall at the time of the burglary.
I was with my friend Taylor. We went all over the place trying to look for my phone.
With your best friend, Taylor.
Yes, it was very fun.
But even in such a public place, no one can confirm that you were there.
I mean, I don't know who saw me.
No one in this court today besides Taylor Perkins can confirm that you were at the mall.
I don't think so. I mean, we were at the
You
fry
do
shop
not
too.
have a timeline of your whereabouts at the mall.
I don't know.
Now, you love your phone, correct?
Well, yeah, it's like my third kidney.
But you didn't look for your phone anytime after you left the fry shack, did you?
Well,
Can you please keep that to a yes or no response?
No, we really didn't.
And you didn't look for your phone when you had to turn it into your mom at night?
Again, I still haven't found it to this day, so I didn't have it.
Thank you, Your Honor. No further questions.
All right. Defense, would you like to redirect?
Yes, Your Honor.
All right.
Thank you. Mr. Becker, did you intend to permanently damage Mr. Brackman's car?
No, I didn't. I thought it was a dry erase marker. Thought it would wipe off immediately after.
Do you carry through with everything you say to your mother?
I mean, except for saying that I'll do chores, no, I never.
Did you break into Mackenzie Brackman's home on March 6th?
No, I think that's completely implausible because I don't know where Mr. Brackman lives. And obviously I'd never want to cause him any more pain than I already have.
And finally, Mr. Becker, did you kill Mackenzie Brackman?
Again, that is completely implausible.
Thank you, Your Honor. No further questions for this witness.
All right, with that, let's go ahead and Mr. Becker, you may take a seat and we'll start closing statements.
Your Honor, one moment, please. I have to
yes.
admit the closing argument attorney for the other team.
Oh,
one of
their
teammates had to leave early for a family matter, and we have their stand-in ready to go. And the scoring panelists should have been notified about this change.
Okay, we will wait for them to be admitted then.
Okay. I believe they're online, and I'm sorry, I don't know how to pronounce your name. Cademan?
Yes, my name is Cademan Bergdorf.
Okay, great. So, Your Honor, we can proceed with closing arguments when you are ready.
All right, I am ready. So, prosecution, you're up.
Yes, Your Honor. Permission to proceed?
Yes.
Today, you saw how Avery's resentment, anger, and fury stabbed through Mackenzie Brackman's ribs, fascia, and aorta. Today, you saw not only how resentment, anger, and fury exploded into a deadly lesson, but you saw that Avery Becker had the motive, the means, and the opportunity to commit this crime on March 6th. Now, I would like to direct your attention to jury instruction number 7, the definition of murder in the first degree. Now, the prosecution and the defense agree on the place and the time of the murder, that the perpetrator broke into Brackman's house with the intent to at minimum destroy, and that Mr. Brackman was killed as a result. The only issue that the prosecution and defense disagree on is identity. Today, the prosecution showed you beyond a reasonable doubt that Avery Becker is the perpetrator. Kyle Kuzak and Detective Markowitz, the two most experienced detectives in this court, both identify Avery Becker as the intruder. From the cell phone data to the plan that Avery set into play and to the pattern of the crime itself, all paths lead to Avery. Now, Avery Becker tried to tell you that he's innocent, but Avery has no explanation to how his phone was tracked from his house to Mr. Brackman's house. In fact, you heard him on direct examination say that he was in a fit of rage towards Mr. Brackman just days before the murder. And Avery Becker has no explanation for how not one person knew he was at the mall that day, except for Taylor Perkins, Avery's best friend. But even though they consulted each other before talking to police about how Alex and Blair and fake texts, as quoted from Taylor Perkins Direct, even though they consulted each other about this, they couldn't come up with an actual timeline for their alibi. The only other witness that the defense brought today was Professor Van Owens, who conducted a brief investigation, talked to two people, and came up with conclusions that don't refute the bottom line, which is the culmination of these facts point to one person, and a couple of scattershot hypotheticals don't establish reasonable doubt. They don't refute the fact that either way, Avery Becker still had the means, the motive, and the opportunity. Alex Cifuentes told you exactly why Avery committed this crime. Alex showed you how Avery's feelings towards Brackman evolved from mere resentment, as Avery could not accept Coach Brackman's criticisms in practice, to anger as Avery grabbed a permanent marker, stormed out of practice in broad daylight, and destroyed the hood of Brackman's Porsche. And then finally to fury, as Avery texts Alex, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. That'll show him for taking away something that Avery told you meant everything to him. This is exactly what Avery told his mom the day or the night of the time that he vandalized Mr. Brackman's car. That'll show him for not giving Avery the chance to bribe his way back onto the team. After seeing his house, Mr. Brackman would never again take this opportunity away from Avery, because Avery planned to teach him a lesson. It turned out to be a deadly one. Avery Becker entered Mr. Brackman's house, but this wasn't a surprise. Why? Because resentment, anger, fury. Because when Mr. Brackman doesn't let Becker do what Becker wants, Avery Becker goes to get revenge. On March 6th, Avery Becker tried to get revenge, tried to teach Mr. Brackman a lesson, but this time it went too far. The prosecution showed you the identity of the perpetrator, and now you have to convict Avery Becker of second-degree burglary and murder in the first degree. Thank you.
All right. Defense, your closing argument.
Good afternoon. May it please the court, your honor, opposing and co-counsel, members of the jury. Implausible, incompetent, insecure. These three words were used at the beginning of this trial by Ms. Chidambaram, and it is within these three words that the truth of this case was found. Avery Becker is a high schooler. He was kicked out of mock trial despite trying to appease an adult who put him down. The prosecution wants you to conclude he committed murder because of that. It is implausible for Mr. Becker to have committed this crime. It does not fit his character. It is the incompetence of both Detective Jordan Markowitz and Kyle Kuzak that have led to the accusation of Avery Becker. Alex Cifuentes was insecure about his position in mock trial. Cifuentes had the insecurity that motivated him to take action, including presented unverified text messages between himself and Mr. Becker. This is the evidence that the prosecution has placed before you to ask you to find Avery Becker guilty of the serious crime of murder. Make no mistake, this is a solemn occasion, and your responsibility as a fact finder is significant. Members of the jury, the death of Mackenzie Brackman was devastating, but declaring a child guilty based on incompetent investigation riddled with bias would be a horrible tragedy. It does nothing to honor his memory. It is the burden of the prosecution to prove beyond a reasonable doubt that Avery Becker unlawfully entered the dwelling of Mackenzie Brackman, knowingly and willingly damaged his personal property, and that these two crimes ended in the murder of Mr. Brackman. Ladies and gentlemen, they have not met their burden. And furthermore, the prosecution has failed to do the required task of identifying the defendant in this case. Detective Markowitz's evaluation of the crime scene was rushed. What is the actual evidence Avery Becker was there? A video of a person of unknown sex, age, or race, obscuring all identifying characteristics? Incomplete cell phone data with conclusions that make unreasonable assumptions? The assumption that Avery Becker was even with his cell phone. Remember that Avery Becker, sworn to tell the truth, told you that the cell phone was not with him at the time. Detective Markowitz and his team were responsible for maintaining the integrity of the evidence, which they did not. The prosecution's own witnesses admitted that the investigative team lost critical pieces of evidence. Multiple photographs of blood drops and blood splatter that were never able to be recovered. Alex Cifuentes' phone, which has been lost forever. We will never know what those texts look like in their original form. Losing critical evidence is not competent. The accusation here is murder. Next, Kyle Kuzak uses this corrupted evidence in order to push the prosecution's theory. Kuzak confirms the disappearance of the photographs and still bases her opinion in the memory of those lost evidence. Kuzak may have impressed you with her technique, but in the end, crime scene reconstruction is just imagining what may have happened. The prosecution that brought Alex Cifuentes to distort Avery Becker's character. Cifuentes was jealous and insecure. You have never seen original text if there were any. Professor Blake Van Owen is someone who has years of experience in the field of law enforcement. He told you the investigation done by the prosecution was rushed, that they ignored obvious details. The investigative team could have done more and chose not to. Taylor Perkins was with Avery Becker on the day of the murder, and the whole time they were searching for a lost phone that has not been found. They were not at Mr. Brackman's house, they were at the mall. This is consistent with what Avery told you. Ask yourself, is there other explanations for what happened that day? Had the prosecution proved every element they were required to prove? If you have any doubts about the prosecution's theory, ladies and gentlemen, your responsibility is to acquit. They have not proven beyond a reasonable doubt. We are all entitled to a presumption of innocence that is fundamental to our way of life. Implausible, incompetent, insecure. We ask you to find Avery Becker not guilty of all
That's
charges.
time.
All right. So with that, monitor, am
Your
I
Honor?
supposed? Yes.
At the beginning of our trial, the prosecution had a preliminary matter about a rebuttal.
Yes, you did. Do you have any remaining time left?
She has
I do
51
believe I-
seconds remaining.
51 seconds, then please deliver your rebuttal.
Yes, Your Honor. Permission to proceed?
Go ahead.
Implausible, incompetent, and insecure. Blair Rowlands, and anyone else for that matter, is implausible because the defense's key investigator, Van Owens, didn't even bother to mention her or any possible other suspect. The key investigator is incompetent because he barely spent a day on this case and isn't even qualified in the fields that he criticized. And Avery was insecure and losing something that meant everything to him. Now, you saw the 3 pings of the CDR. You saw the odds. You saw the odds that Avery did this because Avery was missing on the day. Avery sent the text messages that coincided with what Avery said to her mom. The 3 pings. Avery was guilty. Thank you, Your Honor.
All right. Am I supposed to deliver a verdict at the end of this?
No, Your Honor. At this time, we will ask the scoring panelists to submit their score sheets. Scoring panelists, if you need a link to that form, please let me know. While the panelists are doing that, Your Honor, you may provide feedback to the students if you wish. The scoring panelists have opted to forego feedback in the interest of time, but I think it's okay for you to provide some while they are scoring.
Okay, yes. I will go ahead and start with Colby. I thought that you had a lot of poise. You were very clear with your enunciation. I thought you did a good job drawing out your evidence, introducing exhibits, and responding to rebuttals to objections. I thought your cross-examination was also very good, very quick, snappy, and I appreciate that. You also listed a lot of good facts. Sarina, I think that you did really good. Honestly, all of you were very poised, very well practiced, and I think that was fantastic. I believe that your cross of Becker was I think it was pretty good. You could have elicited a bit more facts from him, I feel like, but overall you did get out a lot of good information, and I appreciated your impeachment during that.
Your Honor, we do have all of the score sheets in. Do you have any final feedback or remarks you'd like to make?
Yeah, I'll just address the group because we're being quick about this. You all did a really great job. I could tell that you all put a lot of work into this. You knew your rules of evidence, made good objections, argued well on your feet. So overall, good job. Well done.